Hello everyone, welcome to the Port Calls YouTube channel. For this video, we are sharing with you a webinar we recently had on dispute settlement and protest, how to successfully defend customs value. The participants were made to understand what customs value is and how this is determined. They learned mechanisms on dispute settlement and protest, and they were told of available remedies an importer has. Let us get to know our speaker.
Mr. Erwin Andaya, but I call him Attorney Erwin Andaya because he is a lawyer and indeed an exemplary passer in the 2021 bar examinations of the Supreme Court of the Philippines, belonging to the top 9% out of the 8,241 passers out of 11,402 examinees. Excited na kayo? There's more. I'm going to get tired letting you know I'm making pakilala the speaker to you. He is a licensed customs broker, third placer in the licensure exams. He is the vice president for professional development of the Chamber of Customs Brokers, Inc., Cebu chapter. Administrative officer at the Bureau of Customs Port of Cebu. Commissioner representing Visayas as Department Assistant Secretary at the National Youth Commissions, Office of the President in Malacanang, Manila. Attorney Andaya is a seasoned lecturer and consultant at the University of Cebu College of Customs Administration, Adamson University Graduate School of Business Administration, and CLAP Customs Review and Center for Professional Development, Pedresa Customs and Tariff webinars. Among these subjects of expertise are as follows. I'm not going to mention all because it might take the whole afternoon. He teaches international customs law and policies, industrial management, customs administrative and judicial proceedings, customs procedures and practices, ethics in customs broker profession, reviewing customs laws and implementing rules and regulations. See, I got tired already, but there's more. There's more. That's not all of the subjects that he teaches. Attorney Andaya is also the favorite speaker to be invited, just like now. He record calls and also at the Gordon College, University of Cebu, College of Customs Administration, Lyceum of the Philippines, Laguna, Philippine Coast Guard, Central Visayas District, and the Philippine Association of Customs Brokers in Education. Even Rotary Club of Cebu Port Center has invited him to speak about updates and initiatives in the Bureau of Customs at the Port of Cebu during the pandemic. That's not all the places. I actually just chose. There's a lot to tell you about Attorney Andaya. Other webinar or some of the webinar topics Attorney Andaya has given include advanced ruling on tariff classification, customs valuation and rules of origin, trade regulations of import and export of food products, protests and appeals in protest and forfeiture cases, liabilities of customs brokers, a survey of Supreme Court decisions, Bureau of Customs, mandates and functions with Customs Modernization and Tariff Act, import documents and licenses, formal and informal entry procedures, advanced ruling on tariff classification, customs valuation and rules of origin, and goods declaration, and many, 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 many more. Attorney Andaya has completed his Juris Doctor very recently, degree at the University of Cebu School of Law. He holds a master's degree in business administration, major in human resource management and development at the University of Cebu, and another master's degree in public administration at the Cebu Technical University. He obtained his degree in Bachelor of Science, graduated magna cum laude in Customs Administration at the University of Cebu. I can't believe it, Attorney Andaya, I finished it. And that's not even all of what you have done. How are you? It's a pleasure to have you. Good afternoon.
Good afternoon, Ms. Mariel. Thank you for the kind introduction. Can you hear me? Thank you very much. So
yeah, I'm coughing. I'm coughing after that long introduction.
Thank you, thank you, thank you. So thank you for inviting me to give a lecture on this topic. So please allow me to share my screen. Can you see my screen?
We can. Yes, we can. Go ahead.
Thank you. So good afternoon once again. Maayong hapon. Magandang hapon po sa ating lahat. Mayad na hapon. Maupay na kulop. Assalamualaikum warahmatullahi wabarakatuh. Thank you, Port Calls, for inviting me to speak about this topic on dispute settlement and protest, how to successfully defend customs value. So you may ask, okay, I am Erwin Andaya, and you might ask, what does a customs service officer of a customer care center have a business to do about that topic? So this was me when I took my lawyer's oath before the Supreme Court of the Philippines, and as earlier mentioned by Ms. Mariel, with God's grace, I passed the bar examination with exemplary performance. So unlike the previous bar examinations, which hold the traditional top 10 or the top notchers, our bar exam instead listed the examinees with scores of 85% and above. And fortunately, I got the rating of 87.88%. So after passing the bar examination, hashtag best bar ever, I was tasked to assist the law division, assessment division, and the liquidation and billing division on the resolution of dispute settlement cases, deficiency cases, and applications for refund. So with these assignments that I have, I believe that I could help you understand our topic this afternoon. And as I've also mentioned by Ms. Mariel earlier, I do lecture in certain schools. So as a lecturer, I prepared materials for my students. So these are the two materials that I have prepared for them. And with the aim of promoting awareness about customs laws and the latest procedures, I also have this Facebook page. So parang nagpa-plug din o parang artista din. So where I post online on the latest issuances of the Bureau of Customs and on the latest rules and regulations. If you want to know more about customs laws and the latest developments of the Bureau of Customs, please free to like and share my Facebook page. So enough with the plugging. Let's start with our lecture this afternoon. Earlier, Ms. Mariel mentioned about the objectives for our webinar and what we expect to happen this afternoon. So let me just repeat it for emphasis. After the end of the lecture, we'll be able to know and understand the following things. Number one, the concept of customs value. Reading the list of participants this afternoon speaks of the relevance, I believe, of the topic, as most of you deal with the Bureau of Customs and various government agencies. And this could have been a rest day for all of you, as mentioned also earlier by Ms. Mariel. It's raining cats and dogs in Manila, but you chose to take part of this activity this afternoon and spend the rest of your 3 hours with us. So with that, marami pong salamat. So I see in the list of participants, we have our friends from the Philippine Economic Zone Authority, some of my colleagues from the Bureau of Customs, and then some also friends from the Philippine Ports Authority, some of my students from Adamson University and University of Cebu. And I also like to specifically mention one of our customs administrator educators. We have Mr. Michael Tede. So with all of you, looking on the list of the participants, so most of you here are in the import and export industry. So I hope that we'll be able to help you understand the complexities of customs regulations and these particular concepts. Next would be the concept of dispute settlement and protest. Ano ba yung kaibahan ng dispute settlement? Ano ba yung protest? When does customs dispute settlement arise? Okay? When is protest the available remedy of the importer? The mechanisms on dispute settlement and protest. How do we file? How do we initiate dispute settlement case? When do we file a protest? To whom shall we file a protest? What are the requirements in filing the protest? And lastly, the available remedies of the importer in cases where dispute settlement and protest could no longer be available. So let's have a brief review on specific and significant terms. Number one, what do we understand by customs value? You may write in the chat box if you want to participate. Ano ba yung naintindihan nyo when it comes to customs value. So customs value refers to the value of the goods for the purposes of levying, assessing, and collecting customs duties. Ad valorem customs duties for that matter. Ad valorem duties refer to the customs duty levied in accordance with the value of the goods. And these ad valorem duties are usually expressed as percentage of the value. These duties are distinct from the specific duties, which are based on specific measures of the goods, such as the weight, the quantity, the number, the volume, the area, and the capacity. In the Philippines, our customs duties are based on the value of the goods. So we apply the ad valorem type of customs duties. This is shown by the fact that we got our tariff rates as shown in your ASEAN Harmonized Tariff Nomenclature, your tariff books expressed in percentage. So you see in your EHTN, in your tariff book, you have the description, the headings, the subheadings, and then you can see on the right portion, the rate of duty expressed in percentage. So if we take this as an example, when the declared value, let us say, is 10 million pesos, and the rate of duty is 10%, based on the tariff book, the specific commodity, the tariff heading of that specific commodity would tell us that the rate of duty applicable is 10%. So the customs duty is 1 million pesos. And this customs duty is a type of ad valorem duty. Granting that the customs duty is based, and as we've learned that the customs duty is based on the customs value, the next logical question would be, how is customs value determined? How do we know the customs value of that certain commodity? Well, the answer to that depends on the local legislation, the legislation of each country. And as far as the Philippines is concerned, our basis is Republic Act number 10863, or most commonly known as the Customs Modernization and Tariff Act. In particular, under Title 7, Section 700 of such law. So if I may ask our attendees this afternoon, can you recall when was the CMTA passed? Can you answer in the chat box? Or will I be able to see your answers, if ever, in the chat box? When was the CMTA passed? Okay, there's an answer here. It was passed on, okay, there's a date saying it was passed on June 16, 2016. I also see here an answer that it was passed on May 30, 2016. There's also an answer that was passed on June 1, 2016. So the correct answer is the law, or the CMTA, was passed on May 30, 2016. In fact, yes. In fact, it was the late President Benigno Aquino III who signed the law on May 30, 2016. Okay. And according to the last section of the CMTA, unlike the other laws passed by Congress, CMTA does not start with Section 1. For example, if I may ask some of our friends in the profession who are customs brokers, the law that governs our profession is Republic Act number 9280, otherwise known as the Customs Brokers Act of 2004. And if you read the law, the text of the law, the section, okay, the starting section is Section 1, and it talks about the title of the law. But in the CMTA, it does not start with Section 1. It starts with Section 100, just like its predecessor, the Tariff and Customs Code of the Philippines. So we have Title 1, Section 100, Title 2, Section 200, and then the last title, Title 18, which includes Section 1800 to 1805. So the last section is Section 1805. It mentions about the effectivity clause. And why is there a need? If you read Section 1805, it says that the CMTA takes effect 15 days after its publication in the official gazette or in a newspaper of general circulation. Why do you think there is a need for the CMTA to be published? Anyone? Let's see some of your answers. Why do you think the CMTA or laws have to be published? Well, the
Go
legal
ahead,
basis.
type your answers.
Yes. Let's wait for your answers. Anyone?
Don't be shy, ha? Don't be shy. Type your
Huwag kayong
answers.
mahiya. Tayo-tayo lang naman yung nandito. We're only 115 here. Okay. Correct. Miss Jovelyn Alberto mentioned for public awareness before implementation. That's correct. Under Article 2, okay, Article 3 of the Civil Code, it says, ignorance of the law excuses no one from compliance therewith. The Latin phrase is ignorantia legis non excusat. It basically means that you cannot be excused from following the law just because you do not know the law. So hindi mo pwedeng sabihin, ay, hindi ko alam na hindi pala pwedeng magnakaw. Hindi ko alam na meron palang batas na hindi pala pwedeng gumawa ng ganito. So you cannot excuse yourself from saying that you do not know the law because there is such a thing as constructive notice. Okay? And how does constructive notice operate? The due process clause of the Constitution requires that before a person can be held liable for a specific violation or before a person can be burdened by what the law requires, the law must be published. Okay? How will you expect that a person to commit a crime and excuse himself if he does not know the law, di ba? So kaya merong constructive notice through the publication, and that's the reason that CMTA needs to be published or needed to be published as well as any other law in accordance with the provision of Article 2 of the Civil Code of the Philippines. So correct si Ms. Jovelyn. There is a need to publish the law for public awareness so that people will be able to comply with the law. That is the nature of constructive notice. Now, the CMTA takes effect 15 days after its publication. It was passed on May 30, 2016. It was published on June 1, 2016. And in accordance with Section 1805, when do you think did the CMTA take effect? If it was published on June 1, sabi nga ng Section 1805, the law takes effect 15 days after its publication. So if it was published in Manila Bulletin on June 1, then it took effect on June 16, 2016. So correct, Miss Jovelyn Alberto, Miss Jacqueline, and Miss Jackie Ochong. So you're correct in saying that the CMTA took effect on June 16, 2016. But prior to the CMTA, before the CMTA, the law applicable as far as the determination of customs value is concerned is Section 200 of the Tariff and Customs Code of the Philippines. Nung nag-aaral pa ako ng Customs Administration, the law that we were reading, the law that we tried to memorize in order to pass the board examination was the old Tariff and Customs Code of the Philippines. How old is the Tariff and Customs Code of the Philippines? Hindi pa ako ipinanganak, nandun na yung batas na yan. That is Republic Act number 1937, passed in 1957. And that law went into several amendments, the latest of which is the PD 1464 during the time of the late President Ferdinand Marcos. And according to, let's have a bit of history, okay? According to Ramon Clarete, a known economics professor at the UP School of Economics, in his article, Philippines Adopting the Transaction Basis for Customs Valuation, he mentioned that since 1972, there have been efforts made to publish the home consumption values. So prior pala dito sa CMTA, prior to year 2000, the customs valuation that we were using was the home consumption value, which is the wholesale price of the goods at about the time of exportation from the principal markets in the country of exportation. However, because of the problems encountered by the customs authorities during that time, there was a need to amend the law in order for the customs administration to be responsive to the demands of the time. So came in March 1987 when through Executive Order number 186, customs authorities used the fair market value, which were defined as the wholesale price of the merchandise in the principal market of the exporting country. And through this executive order, we have the published values at the Bureau of Customs. So dati, if you want to transact with the Bureau of Customs and if you want to know the value of your goods, you have to look on the published values. Merong corner sa Bureau of Customs na kung saan pinopost, okay? Pinopost ng atin pong mga customs officials yung published values which will be used by the importers, by the transacting brokers with the Bureau of Customs in declaring their customs value. And because of our commitment, okay, because of our commitment with the World Trade Organization, when the Philippine government incorporated into domestic law, okay, a little bit of international law, okay. International law, in order for it to be operative in our country, we have two types of methods. Okay, number one, the doctrine of incorporation. And that is stated, that can be found in the Constitution. In particular, Article 2, Section 2 of the Constitution, when it says that the Philippines adopts the generally accepted principles of international law as part of the law of the land. So if there's a particular international law, even without a domestic law, even without a law passed by Congress, we recognize that international law by virtue of the doctrine of incorporation. If I may cite, for example, if you recall, we have a senator who ran for the presidency years ago, and then when she ran for the presidency, there were cases filed against her because according to the petitioners then, she was a foundling. Okay? She was a foundling. And under the Constitution, in order for a person to be eligible to run for the presidency, you have to be a natural-born Filipino citizen. And when can you be a natural-born Filipino citizen? When your father or your mother is also a Filipino citizen. Now, ang tanong nila noon, how will you know the father or the mother of a person who is foundling? Nahanap siya sa, I think, isang simbahan. And how will we know na yung parents niya are Filipinos? But the Supreme Court ruled that even if there is no law specifically providing citizenship to a foundling, walang batas na nagsasabi kung anong citizenship ng foundling. But because there are international laws declaring that a foundling must be given citizenship, the Supreme Court ruled that the foundling is a Filipino citizen. So that's how international law is applied in our jurisdiction. That's a doctrine of incorporation. There's no need for us to make a law. By the very fact that there is an international law, then we adopt it as a law of our land. A second method is the doctrine of transformation. What does the doctrine of transformation say? It says that an international law must be transformed into a domestic law. How do we do that? The text of the international law will be passed as a law in the Philippines. So that's what we do when it comes to the rules on customs valuation. In 1996, in compliance with our requirement and our obligations with the World Trade Organization, the Philippine government passed the law amending Section 200 of the Tariff and Customs Code of the Philippines. And with that, the basis of our customs value is transaction value. So under Section 700 of the CMTA, that is just a copy, okay, that was patterned after Section 200 of the Tariff and Customs Code of the Philippines. And under Section 700, imported goods shall be valued according to the provisions of Section 701 whenever the conditions prescribed therein are fulfilled. And according to the Agreement on Customs Valuation, To the greatest extent possible, the basis of customs value should be transaction value. And that's why in our CMTA, if you read section 701, it is clearly provided that our customs value is transaction value. We will define transaction value in the next slide. So what if transaction value cannot be used or cannot be determined under the provisions of section 701? What do? Will we just come up with a value and make it the value of the goods? No. The rules provide that if ever the customs value cannot be determined by using the transaction valuation method, then we proceed sequentially according to the succeeding sections. And these are, number one, the comparative value method on transaction value of identical goods. I think most of our attendees here are familiar with the methods of valuation. So transaction value of identical goods says that if the customs value of the goods cannot be determined under the first method, then the value shall be determined under method 2, or the transaction value of identical goods. When sold for export to the Philippines, exported at or about the same time as the goods being valued, at or about the same time refers to 45 days before and 45 days after the importation of the goods being valued. And identical goods are goods which are the same in all respects, magkahalintulad in all respects, including physical characteristics, the quality, and the reputation. And these goods are produced by the same manufacturer and in the same country as the goods being valued. If customs cannot determine the value under method 2, then we proceed to method 3. And in method 3, it says the transaction value of similar goods. And similar goods are those that, although are not alike in all respects, hindi sila katulad dun sa identical goods, they have like characteristics, like component materials, capable of performing the same functions, commercially interchangeable, produced in the same country, and produced by the same producer. If we could not determine customs value using method 3, then we proceed to method 4, or the deductive value method. And this is based on the unit price at which the imported goods or identical or similar goods are sold in the Philippines in the same condition as when they are imported in the greatest aggregate quantity at or about the same time of importation. And if we cannot proceed with method 4, then we'll proceed to method 5, the computed value, and lastly, the fallback method. And kindly take note that we do not allow the use of fictitious or arbitrary values. So we have these specific rules on customs valuation that we have to follow. We mentioned earlier that the basis of customs value is the transaction value. So what is transaction value? Okay, transaction value, according to section 700 of the CMT in section 701, transaction value refers to the price actually paid or payable for the goods when sold for export into the Philippines, subject to certain adjustments and certain conditions. What does the PATP represent? Yung price actually paid or payable. The price actually paid or payable represents the total payment made or to be made by the buyer or the importer. So for example, let us say an importer in the Philippines bought cars from Japan. So the amount that the importer in the Philippines paid for the cars represent the price actually paid. Or if it's on credit, let us say after 90 days or after 120 days, then that is the price payable to the cars sold into the Philippines. And the payment according to the valuation agreement may be made not only in the form of transfer of money, but also by way of letters of credit or negotiable instruments. And lastly, payments may also be made directly or indirectly. So for example, you don't need to pay in cash, but the supplier abroad has an existing obligation with the importer in the Philippines. And the supplier abroad said that, do you want me to pay you not in cash but in the form of goods? And then when the importer agreed, then there is still payment, and that is indirect payment. Okay, I'd like to highlight the word sold. Why? Because in order for transaction value or the transaction value method, method 1 to be applicable, there must be actual sale. Merong sale transaction. Although the word sale or the word sold is not clearly or explicitly defined under the rules, the World Customs Organization advisory opinion mentions that sale may be described as any commercial activity which involves a buyer and a seller. So there must be a buyer and a seller, where the buyer agrees to obtain the certain goods, and there is an agreement to exchange ownership over the goods in compliance with certain obligation. And there must be, the parties must both acknowledge that the relationship that they have is one of commercial operation. So, ano ba yung mga situations when there is no sale? Okay. The agreement also provides the no sale scenarios. And these are, number 1, free consignment. Okay. In free consignment, the seller would just leave the goods at the premises of the buyer, and the buyer will only pay the seller when the goods are actually sold. So that's free consignment. And according to the rules, free consignment does not make it a sale transaction. So there's no sale in free consignment. There's also no sale if the goods are only imported as gifts or as samples or as promotional items. So if ever you are a new business player, you're a new importer, and you wanted to import goods in order for it to be used as samples or promotional items, then transaction valuation method cannot be used because there is no actual sale transaction. So we move on to the next method of valuation. Sold for export. Okay, it requires that there is international transfer. So that means domestic transfer is not included. So a sale in Manila to Cebu or a sale in Cebu to Davao is not part of the price actually paid or payable because it only involves domestic transaction. In order for a value to be considered as the price actually paid or payable, it must be one which involves international transfer. There must be exportation from abroad or importation into the Philippines. And the definition also provides certain conditions. So what are the conditions in order for us to determine if transaction value method can be applied? There are 4 conditions with the acronym or code name ACRC. Okay. A, there must be an actual sale, that I've mentioned earlier. There must be no restrictions on the disposition of the goods other than those required by law. Okay. And the sale must be is not subject to certain conditions by which the value of the goods cannot be determined. And lastly, the buyer and the seller are not related parties, or if ever they are related parties, the price is not affected by such relationship. Okay, so I think we've understood what transaction value means, what price actually paid or payable mean. Just a little trivia. Can you guess? Okay, can you guess how many times does the phrase price actually paid or payable appear in the entire Customs Modernization and Tariff Act? Can anyone guess? Ilang beses po ba nag-appear? Ilang beses po bang mababasa natin yung phrase na price actually paid or payable in the entire Customs Modernization and Tariff Act? Can anyone guess? Baka magbibigay ng premyo si Miss Mariel and Port Calls.
Meron bang clue? Can you give us a clue?
Okay, clue. It's more than 1, but less than 100.
Okay.
Sige. Can anyone guess?
I'm waiting. It's just a guess.
Guess lang naman.
Sana yung guess, no wrong or right answer. Kaso
Okay.
it has to be exact.
10 times, sabi ni Miss Jovelyn. Higher po ng 10.
Higher pa than 10.
Yes.
24.
Lower than 24.
Ayan na.
Oh, yan na. Lumilit na.
25, hindi na po
Higher
25.
than 10 but less than 24.
18, ayan na, tamang answer.
Less than 18.
Less than
Less
18.
than 18.
15? That's
Less
also my
than
answer.
15.
Less than 15.
Less
13.
than 13.
12.
12. Correct. Miss Jackie
Yay.
and Miss Jackie, Miss Rachel got the correct answer. The phrase price actually paid or payable appeared 12 times in the entire Customs Modernization and Tariff Act. Now, ano ba yung price actually paid or payable? We've mentioned earlier that it refers to the total payment made or to be made by the buyer, and this can be found in the commercial invoice. So kung anong nakalagay sa commercial invoice, FOB value, CIF value, CFR value, that represents the price actually paid or payable. These are the things that you need to prepare in order to defend your customs value, in order to prove that the declared value is the price actually paid or payable. First, your commercial invoice. You need a commercial invoice because that is where we find the value of the goods. Bank transfer record. That would tell us that the invoice price is actually the price that you pay because there is transfer of money from the importer, from the buyer to the seller. If you have a sales contract, then that would also be better because an importation may be just a part of the sales contract. For example, if the sales contract involved the sale of 1,000 cars, and then you don't import the cars in just one time, you distribute them according to the number of orders. So you have the first importation at 100 cars, second importation by 50 cars. So kapag ganyan, a sales contract can be helpful because customs will know that the shipment is only a portion of the entire sales contract. Another would be a purchase order because that would tell us that your purchase was properly communicated to the seller, and then your purchase agreement, if ever you have any. So these are the supporting documents that you need to present to customs in order for customs to accept the value, in order for customs to believe that your price actually paid or payable is the transaction value. Now, if you may ask, who is responsible for determining the price actually paid or payable? Is it customs? Trabaho ba ni customs na i-determine yung price actually paid or payable? Who do you think? Can we ask our participants? Who do you think is responsible for the price actually paid or payable?
Is there a letter B? Is there a letter C? There's got to be some clue here.
Okay, there's a letter D, as in dog. D.
D.
D, yes.
D. Bureau of Customs.
Okay, it's letter D. It starts with letter D because it is, yes, it's an importer, but importer is just one of the letter D that I'm looking for. There's a term used by the law. It starts with letter D. It
starts with letter D.
Yes. So if the value is considered as the declared value, then who do you think declares the declared value?
The declarant.
Yes, the declarant.
The declarant.
So according to the law, the person who is responsible for determining the price actually paid or payable, the person who is or who has the responsibility of assuring the accuracy of the customs value is the person who is known as the declarant. And that is explicitly provided under Section 107 of the CMTA. The declarant is a person who has the right to dispose of the goods and the right to lodge the goods declaration with the Bureau of Customs. And some of you here answered importer earlier, and I said that importer is just one of the many or of the four persons are considered as declarant. Because according to Section 106 of the CMTA, the following persons are considered to be declarant. My code dyan is IACE, IACE, IACE. I stands for the importer, being the holder of the bill of lading, being the owner of the goods. A represents the agent or the attorney, in fact, the person who represents the importer or the exporter. C represents customs broker. So just like some of us here who are customs brokers who act under the authority of the importer or the exporter in dealing with the Bureau of Customs. And letter E, exporter, being the owner of the goods from the country of exportation. So I repeat, a declarant is a person who's responsible for determining the price actually paid or payable. And the declarant can either be the importer, the customs broker, the exporter, or any other authorized person of the importer or the exporter. Okay. Is a customs broker responsible for the accuracy of the goods declaration? Yes. Okay. But there is an interesting case, and I think I've mentioned this in one of the webinars we conducted previously with port calls. I don't know if you're familiar with the case of Erwin Remigio versus Sandigan Bayan. In that case, what happened in that case, there was a shipment of a 140-footer container, and then the customs broker filed the goods declaration with the Bureau of Customs, and all the customs broker declared that the shipment contains baking soda, 25,000 sacks of baking soda. And then the corresponding customs duties and taxes were paid. And when the container truck, the truck carrying the container was about to transfer the container to its destination, the operatives from the Armed Forces of the Philippines, yung previous, I think it was the Economic Intelligence and Investigation Bureau, stopped the container somewhere near Santo Domingo Church in Quezon Avenue. And then when the container was stripped and was re-examined, the authorities found that aside from the 25,000 sacks of baking soda, the container or the shipment also contained highly taxable goods. And according to the re-examination conducted, the duties and taxes would amount to more than 1 million pesos. And the case for smuggling was filed against the customs broker because according to the Bureau of Customs, the customs broker falsified the goods declaration. But if you read the case, and I think you've known that the Supreme Court ruled that a customs broker is not required to go beyond the documents presented to him, as long as the customs broker relies in good faith on the documents given to him. But Section 107 also requires the customs broker to be responsible for the accuracy of the goods declaration. So is there an apparent conflict? Okay, kindly take note that the CMTA was passed in 2016 and the ruling of the Supreme Court in the case of Remigio versus Sandigan Bayan was in 2004. So I believe there's no conflict. We just have to harmonize the case and the specific provision of the law. So as long as the declaration of the customs broker is based on the documents presented to him, then there is a presumption that the same were accurate declaration made by the customs broker. Okay, what's next? Okay, another section of the CMTA provides for the declarant to be responsible for the declared value. In particular, Section 412, it requires that a goods declaration must contain the invoice and the accurate and faithful account of the price actually paid or payable for the goods and other adjustments, and that nothing has been omitted or concealed in order to defraud the government. I'd like to invite the attention of our customs broker friends as well as our import and export industry stakeholders. If you happen to see the single administrative document, the single administrative document is the document that you file with the Bureau of Customs, and it contains 69 boxes. The data and the information are listed in 69 boxes. If you read box number 50, that's where you sign. Okay, the customs broker signs in box number 50, as well as the importer, the representative of the importer signs in box number 50. There is a statement that in signing box number 50, you certify that the information contained in the single administrative document in all pages attached to it are, to the best of your knowledge and belief, true and correct. And upon signing that certification, you may be held liable for perjury, okay, or for falsification in case customs found that there was misdeclaration, misclassification, or undervaluation. So you may face not only administrative suspension of your accreditation, but you may also face criminal liabilities. You have to make sure that your goods declaration and the declared value are accurate and represent the price actually paid or payable. Now, can customs question the accuracy of the declared value? What do you think is the answer? Clue, yes or no? Dalawa lang yung clue, yes and no. So what do you think is the answer? Can customs question the accuracy of the declared value? Yes or no?
Is there a letter Y?
Yes, there's a letter Y.
Yes!
What do you think? Yes or no? Yes, yes, yes. Overwhelming yes. And you are all correct. Customs has the power or the authority to question the accuracy of the goods declaration. And that is found in section 707 of the CMTA. It provides that nothing in this section shall be construed as restricting or calling into question the right of the Bureau to ascertain the truth or accuracy of any statement, document, or declaration presented for customs valuation purposes. And in fact, if the Bureau has reason to doubt the accuracy of the goods declaration, the Bureau may require the importers to submit additional documents to prove that the declared value is the price actually paid or payable. Okay? And if the Bureau of Customs determined that the value cannot be ascertained by using method 1, then it will proceed to the succeeding rules on customs valuation. And while pending the determination of the price actually paid or payable, the importer is also given the remedies available. And we will discuss later on what these remedies are. Now, we mentioned, and the law provides, that customs has the authority to determine the accuracy of the goods declaration. What tool does customs use in determining the accuracy of the customs value? Meron bang tool? Do you think meron bang tool, or nagpapahula lang yung Bureau of Customs kung ano yung value? Okay, what do you think? To those who are dealing with the Bureau of Customs, dealing with our office, those who are familiar with how customs transactions are done, do you think there's a tool? Clue. Okay, clue. There's a letter E in that tool. There's a letter E. There's a letter R. Okay, there's a letter I. There's a letter N. Kulang na lang W para magiging first name ko na. What do you think is the tool? Okay, very good. Very good. Our participants are really participative. They know the answer. EVRIS. Meron lang question mark. So siguro pag tinawag natin sila, their answer will be EVRIS?
Correct.
Question mark, di ba? EVRIS? So that's correct. EVRIS or the Everest. Sabi nila EVRIS pero mahirap i-pronounce yung EVRIS. Mahirap banggitin. So ang iba sinasabi nila Everest. Okay, Everest. Everest is the tool that customs use in determining the accuracy of the goods declaration.
So how do you say it properly?
Come again, Miss Mariel?
How do you say it? How do you say it correctly again?
Ako, I use EVRIS.
Okay.
But others say Everest.
Okay.
Everest. Okay. So the EVRIS or Everest was issued pursuant to Customs Memorandum Order number 16-2020. the Enhanced Value Reference Information System. And this system was implemented to help the Bureau of Customs establish a reliable and comprehensive database of reference values that will be used, okay, as reference for the value and classification of goods in compliance with the relevant provisions of the World Trade Organization valuation system. And the EVRIS was established in cooperation with the Webb Fontaine Group. Webb Fontaine is a leading provider for solutions in trade facilitations, okay, using world-class technology. And this is designed to help the Bureau of Customs determine if the declared value represents the transaction value. Okay. The reference values, okay, di ba? Sabi nga natin, Value Reference Information System. What does this system have? Okay, this system has reference values. And these reference values are stored in the EVRIS that serves as a risk management tool to ascertain the veracity of any statement, declaration, or document presented by importers for customs valuation purposes before the Bureau of Customs. Kindly take note, and I would like to emphasize, the values, the reference values in the EVRIS are not substitute values. Okay, I would like to emphasize kasi baka ang notion ng ating mga kasamahan sa industry na kapag ano yung nandun sa EVRIS, yan na yung value ng goods. No, these are not values. These are not the declared values. This is only used as a tool by customs, and this should not be used as substitute values. Okay. The Customs Memorandum Order, and this has been emphasized by the leadership of the Bureau of Customs. The CMO 16-2020 was signed by former Commissioner Ray Leonardo Guerrero. We have a new commissioner now in the person of Commissioner Yogi Filimon Ruiz. He used to be, prior to his appointment as Commissioner of Customs, he is the Director of the Enforcement and Security Service, who exercises supervision over our customs police. So he's now the new commissioner. And it is also his obligation. I think it's one of the marching orders that President Marcos gave him to ensure proper valuation of the goods. Hindi pwedeng gamitin yung reference values of substitute values. Kailangan pa ring sundin ng ating mga assessment personnel yung methods of valuation. Assessment personnel are mandated to value the goods according to the rules of valuation. The EVRIS allows the automatic flagging of undervalued goods and provides lookup tables of identical and similar goods. So what will customs do if the declared value is lower than the reference values? Automatic ba gagamitin yung reference values? No. According to the Customs Memorandum Order, if the declaration was hit by the valuation criteria, that means that, say for example, if the declared value of the goods or of the specific commodity is at $100 per kilogram, that's a declared value, and the reference values, the range, the lowest of the range falls under, let's say, $120. So mas mababa yung declared value. If that happens, then customs officers, our assessment officers, are tasked to strictly scrutinize the documents presented, verify if the declared value represents the price actually paid or payable, and require the importer to submit supporting documents. That's why sinabi ko kanina, hindi dahil bababa yung declared value, automatic na yung gagamitin yung reference values. No, because in that particular, if that particular scenario happens, then the importer will be obliged to present supporting documents, to present additional documents to prove that the declared value of $100, even if below the reference value, represents the price actually paid or payable. So let's have a procedure. Okay, let's have an outline of what would happen. So let us say the importer lodges and files the goods declaration through the value-added service provider. Sige nga, let me ask our attendees now. How many days does an importer have to file the goods declaration? Clue, it's more than one, higher than one, but below 100. But I think you could all answer this question. Simple nito, very basic. How many days does an importer have to file the goods declaration with the Bureau of Customs? How many days?
Type your answers.
Okay, there's an answer here, 15. Okay, that's correct. That's based from section 407. Oh, Miss Jacqueline was very specific. 15 days from the last discharge or from the discharge of the last package on board the carrying vessel or aircraft. That's correct. Under section 407, the goods declaration must be filed or lodged with the Bureau of Customs within a period of 15 days from the date of discharge of the last package from the vessel or aircraft. Now, let me ask you, if you're only given 15 days to file the goods declaration, and it happens that you were not able to submit your goods declaration within the 15-day period, anong mangyayari? What would happen? What would happen? Kakainin na ni customs yung chocolates mo na in-import mo kasi you were not able to file within 15 days? What do you think? Correct. Abandon. Okay, Miss Annalisa is correct. Abandon. For failure of the part of the importer to file the goods declaration within the 15-day period, that would constitute implied abandonment. And why am I saying this? Because our next webinar will be about express and implied abandonment. So if you want to know more about abandonment, kindly join us and register in the next webinar. So tama po. With your failure to file the goods declaration within 15 days, that would constitute implied abandonment. Now, what if hindi nyo kayang, di ba, you have to file the supporting documents, you have to file the invoice, you have to file the bill of lading, you have to file the packing list. Okay, what if your commodity is a regulated commodity? By regulated, ibig sabihin, you can only import the product, the commodity, the good if you have a permit. For example, food products. Food products are regulated by the Food and Drug Administration. And if you import food products, you need to submit the FDA permit, a certificate of product registration, or a certificate of product registration. And what if within the 15-day period, hindi pa maibibigay ni Food and Drug Administration yung inyong certificate of product registration? What would you do? Okay, what would you do? What do you think? Okay, very good, Miss Jovelyn. You can file a provisional goods declaration. And by filing a provisional goods declaration, you have a period of 45 days from the date of filing of your provisional goods declaration to submit whatever lacking documents that you have. Another option would be to file a request for extension of the period to file the goods declaration. Diba, you have 15 days. And kulang yung 15 days. Let us say, may bibigay ng Food and Drug Administration yung permit mo on the 16th day or on the 20th day. So your remedy is to file a request for extension to file the goods declaration. And you'll be given additional 15 days. All in all, you have 30 days to file your goods declaration. Okay, so prelude lang yan para dun sa discussion natin on abandonment. But why I am saying this? Because this is the first step. The first step is the most crucial step, because if ever you do not file the goods declaration on time, you might face paying penalties. If I may share my experience in the Bureau of Customs, meron tayong mga importers who are not regular importers. By regular importers, ibig sabihin they do not import every now and then. Okay, they only import once a year, or perhaps meron lang nagregalo sa kanila nung products from abroad. Okay, we have here let us say a laptop which was a gift from abroad, from a friend in France to a person in the Philippines. And hindi niya alam that he has a period of 15 days to file the goods declaration. Do you know what would happen? You will pay a penalty of 10,000 pesos. Libre na nga, di ba? ibinigay ngang regalo yung laptop para wala kang gagastusin, para hindi ka na bumili, but you will be made liable to pay a penalty. So you have to be very careful when it comes to filing your goods declaration. Now, once the importer files the goods declaration, okay, the next step would be BOC side. And under the goods declaration verification system, the entry refers to the document that you submit will be assigned randomly to a customs examiner. So let us say, for example, customs entry number 1111, okay, filed at the Port of Manila, was assigned to examiner A. Now, when the entry is assigned to examiner A, EVRIS will now work. How will EVRIS work? Okay, titingnan ng system ng EVRIS if the declared value for entry number 111 falls below the range of values. If, in case, the declared value falls below the reference value, what would customs do? Or what would the importer do? As mentioned earlier, under Section 707, the importer will be required to submit supporting documents. So mag-submit na si importer kay customs. When the importer submits the documents with customs, two things will happen. First thing is, na-appreciate ni customs examiner yung ibinigay na documents ni importer. And because of those documents, the examiner was convinced that declared value, even if lower than the reference value, is the price actually paid or payable. Ano yung mga documents na yun? Yung binanggit ko kanina. Commercial invoice, sales contract, bank transfer record, sales agreement, purchase order, purchase agreement, whatever document that you have to prove that that is the price actually paid or payable. And the customs examiner is convinced that your value was the price actually paid or payable. Then the value is accepted. Customs examiner will then check in box number 43 that the method of valuation used was method 1 because that is transaction value. And then after that, si appraiser naman, si customs examiner, ang role niya to examine the goods, to examine the documents, to compute the duties and taxes, to determine the value of the goods in accordance with the methods of valuation. Si appraiser naman, ang role niya to review the work of the examiner. When the appraiser is convinced that the work of the examiner is correct, then proceed to final assessment. By final assessment, ibig sabihin, malalaman na ni importer kung magkano yung babayarang customs duties and taxes. Question, sir, di ba when we lodge the goods declaration, there is already an assessment notice? Yes, that assessment notice is temporary assessment notice. It is only tentative. It's only the assessment based on your own self-assessment. But here, the final assessment is the assessment determined by the Bureau of Customs. As I've mentioned, that's scenario 1, when customs accepts your declared value. What is scenario 2? When customs does not accept your value, or when you were not able to submit the supporting documents, or when your documents are incomplete. What would happen? Well, the customs examiner will check the value reference and will check the values for your identical and similar goods. Diba? The method 1, if method 1 is not applicable, we proceed to method 2. That's the transaction value of identical goods. And if not applicable, then method 3, the transaction value of similar goods. And then the customs examiner will input what method was used and then proceed to final assessment and then payment and release of the goods. Okay. So, what if you fall on the second scenario and you do not agree with the findings of the customs examiner? You do not agree that your price, that your declared value, di ba sabi ni customs examiner, no, your value falls below the reference value. You were not able to submit the supporting documents. So, we are doubtful of your declared value and we believe that your declared value does not represent the price actually paid or payable. What if you do not agree with customs? You insist, no sir, this is the price actually paid or payable. What are your available remedies? What do you think? Okay, what do you think are your available remedies? Okay? Your available remedies are either, ito na yung meat ng ating discussion, either dispute settlement, or after dispute settlement, we proceed to protest. Okay. These are the remedies available under the Customs Modernization and Tariff Act. If you read your CMTA, there is the so-called rule-making power of the Commissioner of Customs that is provided under Section 204 of the CMTA. Section 204 allows the Commissioner of Customs, subject to the approval of the Secretary of Finance, to issue rules and regulations to implement the provisions of the CMTA. Dispute settlement and protest are found under Chapter 1 and Chapter 2 of Title 11 of the CMTA. The Customs Administrative Order number 2-2020 was signed by former Commissioner Ray Leonardo B. Guerrero and approved by the Secretary of Finance on December 19, 2019. And this particular Customs Administrative Order implements Sections 114 on remedy of appeal, Section 425 on tentative assessment, Section 1100 to 1102, and Sections 1106 to 1110 of the CMTA. And this Customs Administrative Order aims to provide a fair and expeditious resolution of dispute settlement in customs issues. You know, under Section 202 of the CMTA, where you find the functions and the mandate of the Bureau of Customs, one of the important functions and mandates of the Bureau of Customs is that of ensuring trade facilitation. So we want our goods to be released in the soonest possible time, in the most efficient and most effective manner. That's why dispute settlement and protest has been devised. This ensures uniformity and consistency in the application of customs regulations on dispute settlement and prescribes our procedures in compliance with our obligations under the revised Kyoto Convention and relevant WTO agreements. Okay, so that's the background of Customs Administrative Order number 2-2020. You may ask, sir, kailan ba available yung dispute settlement? When is dispute settlement available? Under the Customs Administrative Order, dispute settlement is an available remedy in case of dispute as to customs valuation. There's a dispute on the proper use of the methods of valuation. There's a dispute as to the price actually paid or payable. Dispute on the rules of origin. Diba? You have here okay, let me ask our participants. What do you submit to Bureau of Customs if you want to avail of preferential tariff? For example, your commodity originates from Singapore, and under the agreement on trade, okay, under the ATIGA, the agreement on trade in goods, there is a preferential tariff of 0%. So kapag from originating country, if it comes from Singapore or any ASEAN country, the rate of duty is only 0. But if it comes from other countries, the rate of duty is 10%. So let us say you have 1 million pesos as your declared value, your DV, your dutiable value. And then the rate of duty is 0%. O di ba? Mas favorable sa inyo kasi wala kayong babayaran. So what will you do in order to avail of the preferential tariff? You're correct, certificate of origin. And in the determination of the authenticity of the certificate of origin, if merong doubt si customs that your CO is fake, that your CO is not genuine, or that you do not comply with the originating requirements, like for example, there is a requirement that the component material of the good 40%, at least 40% of the component material comes from the originating country. Diba? Yan yung requirement, isang requirement, yung regional value content, the RVC requirement. Oh. And then, let us say for example, there were fish, okay, merong mga isda na kinuha from China. Okay, and then that fish were transported to Singapore. Walang ginawang process. It was only shipped to Singapore because you want to avail of the preferential tariff. Do you think you can avail of it? No, because there was no substantial transformation of the goods. Pinadaan lang, trinanship lang because of your desire to avail of preferential tariff. There was no substantial transformation. So if there was no substantial transformation, then the goods are not considered to have originated from Singapore. So that's an issue involving application of rules of origin. And then that is dispute settlement is available as a remedy. Next, tariff classification. A tariff classification is the process of determining the appropriate heading, okay, in the ASEAN harmonized tariff nomenclature. So what if you classified the goods under a specific tariff heading? Let us say, for example, 1111.1111. That's a tariff heading that you classified your goods. And according to the rate of duty, according to the AHTN, the tariff book, that classification has 1% rate of duty. So maliit lang yung babayaran mong customs duty. But the customs examiner insisted, no, your goods are not classifiable under this specific tariff heading. It should be classifiable under 9999.9999. And that tariff heading has a rate of duty of 30%. Lugi ka. Kasi nga, kung 1 million yung value mo, yung 1% mo is only 10,000 pesos. But with a 30% rate of duty, yung customs duty mo would now be 300,000 pesos. So lugi ka, di ba? You know that difference, the discrepancy that you have to pay with customs? Okay? You have to pay with customs. So in that particular instance, dispute settlement arises. Okay? And dispute settlement is available as a remedy. Okay? Other issues involving assessment, not seizure, not forfeiture, because dispute settlement is not available for seizure and forfeiture. And other issues. Okay. Okay, but our discussion this afternoon will only focus on customs valuation. Kasi nga, yung topic natin is how to defend your customs value. So we will focus on dispute settlement involving customs valuation. Now, is dispute settlement available in all instances? Can dispute settlement be availed of in all instances? Okay, do you think dispute settlement is available in all circumstances? No. Dispute settlement under Section 4.2 of Customs Administrative Order number 02-2020 provides that dispute settlement is not available if the goods is subject of an advance ruling. Ano ba yung advance ruling? Can anyone tell me what advance ruling is? If you recall, under the Customs Modernization and Tariff Act, an importer or an exporter may apply for an advance ruling on customs valuation, tariff classification, or the application of the rules of origin at least 90 days prior to the importation or exportation of the goods. Why do you think is dispute settlement not available if there is a pending application or a resolved decision on advance ruling? Why? Because the Tariff Commission, in case of tariff classification, or the Bureau of Customs, in case of customs valuation and rules of origin, had already decided on your case. So wala nang dispute kasi nga meron ka ng decision. There's already a decision telling you or telling everyone that the goods are classifiable under this specific heading. That's the decision of the Tariff Commission on the advance ruling. There's already a ruling by the Bureau of Customs that the value of the goods is this much. So dispute settlement is not available because all you have to do is to present the advance ruling. Oh, sabi ni Tariff Commission, ito yung classification ng goods. Sabi ni Customs, ito yung value ng goods. So dispute settlement is not available because all you have to do is to present the decision or the ruling of the Tariff Commission or of the Bureau of Customs. Dispute settlement is also not available if there is intentional or fraudulent misclassification, misdeclaration, or undervaluation. Ang code ko dito, mis-you. Ano ba yung misclassification, misdeclaration, and undervaluation? Under Section 4.7 of the Customs Administrative Order, dispute settlement mechanism shall not apply if there is intentional or fraudulent misuse. Ano yung misuse? That's technical smuggling. Diba? That's technical smuggling. Sige nga. What are the two types of smuggling? If you can recall, our dear attendees, what are the two types of smuggling? What do you think are the two types of smuggling? Technical and outright. Correct. Technical and outright. Very participative si Miss Jovelyn. Baka may pa-premyo si Miss Mariel for Miss Jovelyn.
Oo nga, tinitake note ko eh.
Okay. Thank you, Miss Mariel. Thank you, Miss Jovelyn. That's correct. Technical and outright smuggling. Outright smuggling is smuggling na dumaan at hindi dumaan ng customs, sabi nila. Because outright smuggling refers to the act of the importing goods without complete customs prescribed importation documents or without having been cleared by the Bureau of Customs or other regulatory government agencies. That's the definition of outright smuggling under Section 102 letter FF of the CMTA. In essence, ito yung smuggling na hindi dumaan sa customs. For example, merong barko from a foreign vessel na hindi pumunta sa pier, nandun lang sa karagatan. At merong maliit na barko o bangka na lumapit sa kanya. And then from that foreign vessel, merong dinidischarge na mga shipment into that bangka. So that's outright smuggling, hindi dumaan ng customs. Ito namang misuse, ito yung tinatawag nating technical smuggling. Ito yung smuggling na dumaan sa customs. Why? Because technical smuggling is the act of importing goods by means of fraudulent, falsified, or erroneous declaration. And what's the purpose? In order to avoid the payment of duties, taxes, and other charges. Okay, let's have a review. Ano ba yung sabi dito kay Miss Jovelyn, kahit book ko na lang daw. Sige, we'll arrange on that. We'll arrange on that. Sige. So what is misclassification? Misclassification has something to do about the tariff heading. It is the use of the insufficient or wrong description of the goods. For example, kung yung totoong laman ay apples, okay? It should have been classified under apples, but you classified it into balls, basketballs, okay? Or the balls used in basketball or golf balls. Kasi kung titingnan mo sa x-ray, magkalintulad lang siguro yung image niyan. So that's misclassification if you use a wrong or insufficient description of the goods or the use of an inappropriate tariff heading. What's your purpose? Because this particular tariff heading has a lower rate of duty. And if you use the proper tariff heading, mas malaki yung babayaran mong customs duty. So that's misclassification. Misdeclaration also when, for example, if the goods are regulated goods. Let us say, for example, another example would be on the misdeclaration as to the quality. Okay, let us say, mas maliit yung babayarang customs duty kapag hindi na brand new, used na. But the truth of the matter is that ang nasa loob ng shipment ay brand new na nasasakyan. Okay. Let us assume lang let us just assume that a brand new car has a higher rate of duty than a used car. So kahit alam mong brand new car yung nasa loob, i-declare mo siya as used car para lang maka-menos or para lang bumaba yung babayaran mong customs duty. That is misdeclaration. Now, undervaluation. Sinadya mong paliitin yung customs value para mas maliit yung customs duty kasi nga ad valorem siya according to the value. So that's undervaluation. If any of the three is committed, then dispute settlement is not applicable. What would happen? In that case, enforcement issue is deemed to have arisen and When probable cause exists, the district collector may issue a warrant of seizure and detention over the goods. So yung case now would not be a dispute settlement case, but would now be a seizure or forfeiture case. Okay? And kindly take note that when the misdeclaration, misclassification, and undervaluation is knowingly made or intentionally done, a surcharge amounting to 500% of the duty and tax shall be imposed. Okay? So, balikan natin yung pinakita kong kaninang procedure. Let us say, for example, at this level, okay, at this instance, you do not agree, okay, you do not agree with the, okay, you do not agree with the decision of the customs examiner. Then, as I've mentioned, based on the cow, there is now a dispute as to the proper value of the goods. And in that particular instance, dispute settlement on customs valuation is available. So anong gagawin? Anong gagawin mo if ever customs will not accept your customs value? This is now how you defend your customs value. What do? Will you go to court at magpa-issue ng temporary restraining order? Will you go to the president and ask the president to order customs to accept your value? Will you go to the ombudsman and file a complaint against the customs examiner because he does not accept your value? Will you go to the Presidential Anti-Corruption Commission? Where will you go? According to the dispute settlement mechanism, your proper remedy is what? You go to the customs examiner. You submit your documents. If customs examiner does not agree with your documents or does not accept the customs value, you elevate the matter to the next officer. So you elevate that to your principal appraiser. See, customs examiner usually is the COO3, the Customs Operations Officer 3. Si principal appraiser, mas mataas sa kanya, Customs Operations Officer 5. So you go to the customs appraiser. And if the level of the customs appraiser, hindi pa rin ninyo ma-convince si customs appraiser kasi pareho sila ng appreciation ni customs examiner, you go to the next higher official, the chief of the assessment division, which either be the formal entry division or the informal entry division in the ports. Okay. My suggestion in this instance, dapat everything is in writing. You have to put everything in writing so that you can use that whenever the matter is escalated to the next higher authority. If hindi pa rin ma-convince ninyo si chief ng assessment division, then you go to the deputy collector for assessment. Okay? And if sa level ni deputy collector for assessment, hindi pa rin kayo hindi pa rin ninyo ma-settle yung issue, then that's the time you go to the level of the district collector of customs. Okay? Now, what are the useful tips? These are my tips dun sa dispute settlement mechanism. Number 1, you have to make sure you have a copy of your proof of payment. Why? Because in customs valuation issue, the question is on your price actually paid or payable. If you have a proof of payment, then you can say that this is the amount that you pay. Okay. Real life scenario, lalo na yung mga estudyante dito, kung meron pa mga students. Di ba? Kapag merong errand sa atin, like for example, sasabihin ng ating nanay, anak, pumunta ka nga muna sa tindahan, bumili ka nga ng suka. Okay, nandito yung pera, 100 pesos. Bumili ka ng suka. Okay. Nagpunta ka sa tindahan, bumili ka ng suka. Binigay mo yung 100 pesos. Binayaran mo 60 pesos. Okay, so dapat meron pang sukling 40 pesos. But when you arrive in your home, ang ginawa mo, ibinigay mo yung suka sa nanay mo at ibinigay yung 20 pesos na sukli. So sabi ng nanay mo, are you sure? Magkano ba yung suka? Sabihin mo, 80 pesos, nay. Oh, so ito, 20 pesos na yung sukli. Sigurado ka ba na 80 pesos talaga yung presyo ng suka? Anong proof mo na 80 pesos yung binayad mo? Oh, yung resibo, di ba? So that's also applies with customs. What is your proof that that's the amount that you pay? Your proof of payment, your sales contract, your invoice, your bank transfer. Kasi pwede namang hindi ka magbayad ng cash. You can pay through letter of credit, through whatever method. So whatever document you have, whatever record you have that will prove the price actually paid or payable, make sure you have a copy of it. Okay? Then, if you have a copy of it, make sure that either they are original or they are certified true copies. Okay, who certifies the documents? If you will ask me, and based on my experience, this is what we usually require. Yung certified true copy, the documents or the copies must be certified by the person who has custody of the original records. So if bank transaction, if it's a bank record, then you ask the bank to certify, the bank officer, the responsible bank officer to certify the authenticity of your bank record. Okay. Now, when you are submitting your documents to customs, you make sure you put them into writing. You make a position paper. Simple letter lang, okay lang yung simple letter. Basta maintindihan, clearly stated yung facts. Number one, the facts. Yan yung nakakaproblema kami. Like for example, in my case, when I started assisting the law division on resolving dispute settlement cases, nagkakaproblema ako kasi hindi lahat ng facts nandun. Okay? Like for example, number one, ano yung entry number? Yung mismong entry number hindi included dun sa letter ninyo. How will we know? How will I know that your letter corresponds to this specific entry number? So you have to state the facts. You have to state your entry number. The name of the consignee. Okay? Kasi yung entry number is assigned every year. So entry number 1 for this year, if you do not indicate the consignee, might refer to the entry number 1 of another port or of another person. So you have to indicate the name of the consignee. The description of the goods. Okay? The description of the goods. The value of the goods, because it's a customs valuation issue. So you state the value of the goods. Your declared value versus the reference value, the value that customs examiner says to be the value of your goods. Okay? You state your bank transaction record based on the invoice. For example, the declared value is 1 million pesos. So you state there, based on the sales contract, the value of the goods is 1 million pesos. In addition, based on the bank transfer record, we transferred the amount of 1 million pesos in this in favor of the seller at this time, at this date. Okay, so you state the important facts. Next, you state the important dates. When did the goods arrive? When did you file the customs entry? When was the entry received by the customs examiner? When did you know that customs examiner has doubts? Or when did you know that the customs examiner questions your declared value? When did you go to the customs appraiser, di ba? Customs examiner, appraiser, chief ng assessment division, deputy collector, district collector. So you state, when did you go to the customs examiner? When did you go to the customs appraiser? When did you go to the chief ng assessment division? When did you go to the deputy collector for assessment? Why are those important? Because only when you did all those things that a dispute settlement case is validly or has validly arisen, okay, or is valid or is ripened for the action of the district collector. If dumiretso kayo sa district collector, then you did not comply with the procedure. And with that, your case might be dismissed. Okay? Please take note that there is a reglementary period under the CMTA that you have to comply with certain things. For your failure to comply with certain things, then you will lose your right. You will lose the remedies available to you. So you have to make sure you include the material dates. Next, you include your legal basis. Okay? Para din kayong nag-aabogado, di ba? Kasi ako, if I read, let us say, for instance, I read a certain letter, I receive a certain letter from a certain broker. And I was so impressed because the customs broker knows his law. He knows what particular section. He expressly states that under the CMO, reference values are not substitute values. They are only used as a risk management tool. Sinight niya yung mismong CMO. And that is impressive, di ba? That would make my life easier. Why? Kasi kung magbibigay ako ng recommendation kay district collector, yun yung isa-cite ko. Diba? So you have to make legal basis. You have to cite the law because that will help your evaluator, like for example, in my case, as a case evaluator, that would make my recommendation easier. Hindi na ako maghahanap ng legal basis to support your claim. Ikaw na mismo yung nagbibigay sa akin ng support. Ikaw na mismo nagbibigay sa akin ng legal basis to support your claim. And that is very helpful. Okay? So, that's good. You cite the law. You say, under Section 700 of the CMTA, the value is the method of valuation is transaction value. Under Section 701, transaction value refers to the price actually paid or payable. And then you state that under CMO, although there is the EVRIS or the Everest, the reference values are not substitute values. They are only risk management tools that customs will use. So yun, isite mo. Then that would help your case. That would help you build your case. Okay, you cite your legal basis. Next, you cite your relief prayed for. Ito yung pinaka-importante. Kaya nga sabi nila, yung mga abogado daw, yun yung pinaka-prayerful. Yun daw yung yun daw yung unang mapupunta sa langit. Bakit? If you read the pleadings, you know what pleadings are? Pleadings are the documents presented by a lawyer to the court asking for the reliefs. Ano yung gusto mong mangyari? So, dun sa sulat mo, the last portion would be your relief. You state in your last portion, in view of the above premises, in view of all the cited legal provisions, in view of the provisions of the law, it is our request that the customs value as declared be accepted as the dutiable value, be accepted as the customs value, be accepted as the price actually paid or payable. Ganyan sa korte. Pag may pleading, ang pinaka-dulong portion, that's the prayer. Kaya nga sabi nila, prayerful daw ng mga lawyers kasi ang nakalagay dyan sa last portion ng pleading, wherefore, it is respectfully prayed. Diba? Respectfully prayed. Napakagalang po na hinihingi, respectfully prayed upon this honorable court, okay, upon this honorable court to dismiss the case in favor of the defendant, in favor of the respondent. Dapat ganun din sa letter ninyo para kung ako yung evaluator, alam ko anong gusto mong mangyari, di ba? Kasi hindi ko alam wala kang binanggit anong gusto mong mangyari. So sabihin ko, ano bang gustong gawin? Ano bang gusto niyang gawin ko? Ano bang gusto niyang gawin ni customs? So you have to state in your letter what you want customs to do. So it can either be you pray that the value be accepted, or if you want to obtain the release of your goods while pending yung case, then you cite your release under tentative assessment. You cite whatever reliefs you prayed for. Lahat ng gusto mong gawin, i-cite mo na. Before, when kahit ngayon, I'm still with the office of the district collector. The district collector is the head of the port. So nandun ako sa office niya. All the documents, all communications that would go to the district collector, dumadaan sa amin. And whenever we receive letters, yun yung lagi kong sinasabi sa mga sumusulat. You put what you want the district collector to do. 'Di ba? Nagsasabi ka, ganito yung nangyari, yung shipment ko dumating ng ganito, tapos sabi ni customs examiner ganito, tapos sasabihin mo thank you. O anong gagawin ko? 'Di ba? Anong gusto mong gawin namin? So you cite what you want us to do. So if you want customs to accept your value, you cite. It is respectfully prayed, it is respectfully requested that in view of the law, in view of the facts of the case, you request that the customs value be accepted. At yun din yung gagawin ko whenever if ever I'll be the evaluator of your request. Diba? That would make my life easier. Diba? That would help me. So if napakaganda nung sulat nyo, if lahat ng kailangan ko nandun na, then that would make everything easier. That would make transacting with this case more efficient, mas mabilis yung pag-resolve ng case. Another thing, kung meron kayong isa-cite na document, you attach the document. Okay, for example, mayroon kayong letter, di ba? Sasabihin nyo, attorney, ganito, ganyan, district collector, ganito, ganyan, dear sir, greetings or whatever you want, best wishes, kasi alam nyo bagong kasal yung district collector, so best wishes on your wedding, ganito. Then you start on this date the shipment arrived, di ba, ganyan. Okay, or this refers to my dispute settlement case under Customs Administrative Order 02-2020. I have a shipment under Customs Import Entry Number, ganun. I-attach nyo, di ba? So, Customs Import Entry Number 111, herein attached as Annex A. Para at least kung titingnan namin, nandun na yung lahat ng documents, di ba? Hindi na namin hahanapin, hindi na namin tatawagan pa kayo, ma'am, nasan to? Ma'am, ba't wala to dito? Di ba? Mas mabilis yung paggawa ng evaluation. So lahat ang attach as Annex A. Kung meron kayong binanggit na transaction record, you said, the attached transaction record is found in Annex A or in Annex B. Kung meron kayong isa-cite na figure, like for example, invoice, di ba? Invoice, tapos gusto nyo i-highlight yung figure. So the invoice states that the price of the goods is 1 million pesos. I-highlight nyo na dun sa papel. I-circle nyo na o lagyan nyo ng distinguishing mark para pag nakita namin yung document, alam na namin yun yung nire-refer nyong value. Yun yung nire-refer nyong fact. Yun yung nire-refer nyong item doon sa document na ipinipresent ninyo. One time, may binigay sa akin 10 pages na bank transaction record. Ang daming numero. O imagine, I have to spend the whole day checking what amount was involved in the transaction. Wala man lang hinighlight, di ba? Kung hinighlight na yun, di mas mabilis na yung trabaho ko. So that's what you have to do also, our dear stakeholders. So if you present any document, lalo na kung voluminous, number of pages, i-highlight nyo na alin doon yung importanteng makita ni Bureau of Customs. Okay? Okay, I will answer your questions later on, ha. Okay. Para lang hindi maputol yung discussion natin. Okay. So yun na. So you attach all the documents, you highlight the items in the documents that you wish to bring to the attention of the customs evaluator or the customs examiner or of the district collector. Kasi when I do my evaluation, usually kasi disposition form yan. Okay? Disposition form. Nakalagay kasi dyan yung details. That's what we call the facts of the case. Sino yung consignee, ano yung import entry number, anong nangyari, para kang nag-storytelling, okay? Para at least pag nabasa ni district collector, alam niya kung anong nangyari. Para the district collector would appreciate your case. Di ba kung napakaganda mong sinulat yung letter mo, di ba mas na-appreciate mong nagbabasa? Katulad na ng love letter. Di ba? Kung gusto mong i-convey yung feelings mo sa isang tao, kung dadaanin mo sa love letter, ngayon text-text lang, chat-chat lang. Di ba dati love letter, pero mas maganda pa rin yung love letter, di ba? Mas gusto mo na napaka-sincere, honest yung pag-convey mo ng expression ng feelings mo, di ba mas ma-appreciate nung tumanggap nung letter mo? Ganon din po sana kayo sa Bureau of Customs. You state clearly the facts of your case. Diba? Ganon din naman yung gagawin namin. So, if I will be the evaluator at napakaganda ng sulat mo, kukopyahin ko na lang yung sinulat mo. E di mas mabilis yung pag-act namin, di ba? So, you state there. And then, gagawa namin disposition form, lalagay namin yung facts. And then, ilalagay namin yung issue. Bakit nagkaroon ng problema dito? That's the issue. Okay? So, bakit magka-dispute? Because the customs examiner did not appreciate the documents submitted by the declarant, by the importer. So yun yung sasabihin ko doon. The issue, whether or not the documents are acceptable or whether or not the declared value is acceptable. Then isite ko rin yung batas. Kukopyahin ko rin yung sinite mo under Section 700, under Section 701, under Customs Memorandum Order number 16-2010, under Customs Memorandum Order number 16-2020, ganun din, isa-cite ko rin yun, lahat ng legal basis mo. Diba? Especially if the district collector is a lawyer, lalo na kapag lawyer, naghahanap yan ng legal basis. Like for example, in my case, ang boss ko ngayon, lawyer, yung district collector namin, para kung wala naman siguro akong kasamahan dito, no, I think my colleagues here will agree. When we face the district collector, para kaming nag-thesis defense. Why? Kasi if we recommend something, sasabihin ng district collector, What's your legal basis? Where can we find in the CMTA that your recommendation is correct? Where can we find in the rules that your recommendation is the appropriate action? Diba? Ganon din, doon sa gagawin naming recommendation doon sa dispute settlement case mo. Tutulungan nyo rin kami na i-defend yung case nyo, i-defend yung relief na hinihingi nyo. If you want your declared value to be accepted, then you cite the law. Diba? In the case of, kung merong mga Supreme Court case, mas maganda para magandang tingnan. Yun yung diskarte ko. I cite Supreme Court cases. Aside from the law, I cite. For example, in the case of, ganito, in the case of Erwin Remigio versus Sandigan Bayan, ganyan. In the case of People of the Philippines versus ganito. O, kung pwede ko pang i-cite yung World Customs Organization Advisory Opinion, so mas maganda. Di ba? Mas maganda pag ganun para at least, para mas confident yung district collector na i-approve yung request mo. Kasi napakaganda ng legal basis mo. At least kung tatanungin siya ni Commissioner, tama ba itong ginawa mo? O meron kang masasite na legal basis. Diba? Lahat naman, as long as your act is within the law, as long as your request is allowed by law, we will approve your request. Hindi naman ganun kagago, or I'm sorry for the word. Ano ba yung I'm looking for a proper adjective. Hindi naman ganun ka very small-minded yung taga-customs na hindi tanggapin yung declared value nyo. As long as duly supported by the facts, duly supported by the law, duly supported by evidence and documents. Okay? And then at the last portion by disposition form, lalagay ko doon, in view of the premises, it is respectfully recommended that the declared value be accepted. And number 3, if in accord, attached is a reply to, attached is the decision to the dispute settlement case. So gagawa namin yan ng decision. Okay? And that's we submit to the district collector. Okay, yan yung tips ko that applies to even if hindi dispute settlement, even if forfeiture, even if request for application for refund, you include all these things para mas mabilis yung trabaho natin sa Bureau of Customs. Now, what if, okay, di ba, nandun na sa level ni district collector. Di ba yun yung nasa last part ng ating dispute settlement mechanism. Nasa level na ni district collector. Now, at the level of the district collector, two things will happen. Number 1, i-determine ni district collector if the dispute does not involve highly difficult or technical question. Dalawa yan. Does it involve technical or highly difficult issue? If yes, ito yung proseso. If no, ganito din yung process. So unahin natin if the issue is not difficult or highly technical. Now, another useful tip. Mamaya na lang siguro. Mamaya na lang yung tip kong ito para mas ma-appreciate mo. Now, if the district collector thinks that the issue does not involve highly technical or difficult question, then the decision, okay, if the dispute does not involve, the district collector may adopt the findings of the customs officer and issue a ruling. Okay, sasabihin dun sa ruling, I agree with the recommendation of the customs officers, okay, and you, in that ruling, the district collector will notify you within 48 hours from the issuance of the ruling and will direct you to pay the duties and taxes based on the assessment made by the customs examiner or by the customs officer concerned. That is if the question does not involve difficult or highly technical issue. Now, what if yung second scenario? What if it involves difficult or highly technical issue? Sir, how would you know if it's a difficult or highly technical issue? Depende yan on how you argue your case because in the CAW does not define what is a highly difficult or technical issue. Meron akong tip sa inyo mamaya. Okay? Now, if it's a difficult or highly technical issue, the district collector will do these things. Number 1, he will inform the importer within 2 days that the issue is difficult or highly technical. And then the district collector will require you, the importer, and the customs officer concerned to submit position papers. So pagandahan ngayon ng position paper. Kung maganda yung position paper mo, pangit yung position paper ni customs examiner, who do you think is more convincing to the district collector? Sige nga. Kung kayo mismo yung district collector, napakagandang sumulat ng importer, tapos yung customs examiner, hindi masyado. Kanino kaya mas mako-convince yung district collector? Of course, kay importer, di ba? Mas mako-convince siya. Ano na ba to si customs examiner? 1 page lang yung position paper. Yung importer, 10 pages. Tapos lahat ng documents naka-attach. Lahat ng Supreme Court cases na relevant sa case niya, sinite niya. O, di ba? Sino yung mas convincing? Si importer. So, who do you think will the district collector decide for? For the benefit of the importer. Now, after receipt or the position papers or after the expiration of the period, 5 days lang yung ibinigay sa inyo. So you have to make your position. Kaya nga sabi ko kanina, make sure everything is in writing. Why? Para yung sinulat mo doon pa lang sa level ni customs examiner, copy-paste mo na lang para doon sa kay district collector. Imagine, can you work on within 5 days? Hindi. Di ba? Especially if you need documents. Kailangan mo pang pumunta sa bangko, absent yung manager, absent yung magsi-certify, naka-maternity leave, naka-paternity leave, o hahanap ka pa ng ibang taong pipirma. Do you think 5 days is enough? And remember, 5 days here, calendar days. That means including Saturday and Sunday. What if natanggap mo yung notice Friday? Lugi ka na kasi yung Saturday and Sunday counted yun pero walang trabaho. O, di ba? Meron ka na lang 3 araw para gawin yung mga lahat ng kailangan mong gawin. Kung ginawa mo na yun, doon pa lang sa level ni customs examiner, sumulat ka na ng napakagandang sulat sa level ni deputy collector, ni chief ng assessment, tsaka kay customs appraiser, copy-paste mo na lang, di ba? Babaguhin mo na lang yung addressee ng letter mo. Kasi yung sulat na yun, yun yung mismong pinadala mo. So, i-change mo na lang yung addressee ng letter mo. O, di ba? Mas mabilis yung buhay natin. Okay, so yun. And then, the district collector will render a ruling within 15 days from the submission of the position paper. Now, di ba? Tulad nito, meron pang 15 days. What if yung shipment mo dumating ng pier? Let us say, for example, dumating nung July 10. Tapos, yung shipment mo, let us say, gatas yan. Gatas. Kasi gagawa yung isang hotel ng napakaraming milk tea. Okay? O isang tindahan, kailangan ng milk tea. Yung shipment mo, ingredients doon sa milk tea. Paano kung dumating yung shipment mo July 10? Kailangan ng milk tea chain yung ingredients on July 12. Meron ka pang problema dito sa dispute settlement. 15 days pa bago makapag-decide si district collector. Anong mangyayari doon? Hindi mo na na-meet yung orders mo for July 12, di ba? So anong remedy mo? What do you think is your remedy? Okay, your remedy here is release under tentative assessment. Okay, that's your remedy. Meron ho tayong remedy dyan. Huwag kayong mag-alala. Basta alam nyo lang yung batas, alam nyo lang yung karapatan nyo, meron po kayong pwedeng gawin, di ba? Sabi nga ng isang programa, kapag nasa katwiran, ipaglaban mo. O, yun na yun. Kapag alam mo yung batas, alam mo anong karapatan mo, you can fight for your right and you can avail of the remedies provided by law. Buti na lang, nag-attend kayo sa webinar natin ngayon at maa-apply nyo na yung available remedies ninyo sa susunod na mangyari sa inyo yung situation na to. So, if it's a difficult or highly technical issue, there's a remedy while pending yung issue. Napansin nyo ba? May napansin ba kayo? Balik ko lang ha. Dito, kapag difficult or highly technical issue, yung pinakadulo, anong nire-require ni district collector sa inyo? Magbayad ng duties and taxes, di ba? Magbayad ng duties and taxes. Dito sa kabila, dito sa difficult or highly technical issue, meron bang order dito na magbayad ka? Wala, di ba? Anong sinabi ni district collector? Submit ka ng position paper. O, di ba? Walang bayad muna dito. Di ba? But, pending the settlement of your issue at gusto mo nang mailabas yung shipment mo, meron kang remedy. Ang remedy mo, release under tentative assessment. Okay. So anong mangyari dun sa release under tentative assessment? Magbabayad ka ng duties and taxes mo based dun sa declaration mo. So if your declared value is 1 million pesos, 10 million pesos, rate of duty is 1%, then you pay 100,000 pesos. Okay, you pay, magbayad ka sa bangko. 'di ba? Now, what if, 'di ba, nagka-dispute nga kasi sabi ni examiner, no, 10 million is not correct. Okay, 10 million is not correct. Dapat yan 12 million. Tapos kung 12 million yung declared value, of course, yung rate of duty na 1%, yung customs duty mo 120,000. So may difference, 'di ba? Magkano yung difference? How much is the difference? Sige nga, how much is the difference? Anyone? How much is the difference? If anyone can answer. Mathematics lang yan, simple mathematics. How much? 20K, o 'di ba? 20K. Sana yung premyo ni Miss Mariel 20K din. Oh, 'di ba? So 20K, correct. The difference is 20,000 pesos. So what would happen to the difference? That represents the disputed amount. Now, how will customs protect its interest? 'Di ba? Ang gusto ni customs maningil siya ng 120,000. Eh ang pababayad ni customs sa iyo 100,000 eh. What if panalo si customs? Mali ka. Lugi si customs ng 20,000 kasi yung binayaran mo 100,000 lang. Anong mangyayari? What do you think if you're the customs examiner? If you're the Bureau of Customs, how will you protect your interest? Okay, tama. Mag-post ka ng security representing 20,000 pesos. So in effect, ganun din, di ba? Mag-post ka ng cash bond. Magbayad si importer ng 100,000, dadagdagan niya ng cash bond na 20,000 pesos. Kapag nanalo si importer, ibalik sa kanya yung 20,000. Kapag natalo si importer, dagdag sa koleksyon ni Bureau of Customs. Lugi ba si Customs? Hindi. Kasi mababayaran naman siya dun sa bond niya. Lugi ba si importer? Hindi. Kasi na-release niya yung shipment niya, di ba? Then release under tentative assessment. Na-release niya yung shipment niya. Nag-bond lang siya. Kapag nanalo siya, pwede niyang ibalik sa kanya yung binand niya, di ba? And then comply with pertinent regulations. O di ba? Okay. Okay, balik tayo ha kung meron kayong napansin. Dito sa not difficult or highly technical issue, dapat kang magbayad kasi yung demand for you is to pay the duties and taxes. Okay? Pay the duties and taxes. But dito sa difficult or highly technical issue, walang payment of duties and taxes, di ba? Yung babayaran mo lang yung as declared, pero hindi yung disputed amount. Magpo-post ka lang ng bond. Pangalawa, kung dito sa situation na to, ayaw mo magbayad, hindi ma-release yung shipment mo, di ba? Pero dito, pag difficult or highly technical issue, pwede mong ma-release yung shipment mo because there is the remedy of release under tentative assessment. So what am I saying? What am I saying? Ganito yan. 'Di ba? Meron kayong 'di ba? You elevate the matter to the district collector. So susulat ka kay district collector, 'di ba? Banggitin niyo doon sa sulat niyo that the issue is highly technical or highly difficult. Why? Kasi pwede kayong mag-request ng release under tentative assessment. O 'di ba? So ganun. Tapos i-justify niyo bakit mahirap, bakit highly difficult or technical. So that would help us establish your case. Diba? Okay. What if, diba sabi natin kanina, magre-render si district collector ng decision within 15 days. What if ang decision ni district collector agree kay customs officer? Or what if doon kanina sa not difficult or highly technical issue, nag-agree si district collector kay customs officer? Ano yung remedy ninyo? What's next? Doon na ba? Tapos na ba lahat? No. Ano pa yung remedy nyo? Your next remedy is, di ba, what if sabi ni district collector, tama si customs examiner. So yung 20,000 mo na bond, hindi na yan maibabalik sa'yo. Di ba? Magiging part na yan ng collection ni Bureau of Customs. Tama. You're correct. Your remedy now would be to file a protest. Okay, protest. Ulitin ko ha, dispute settlement muna, hindi protest. Maraming cases na dumadating sa akin, dumiretso sila ng protest. Eh syempre, wrong remedy, dismiss. Okay, wrong remedy, dismiss. Kaya dapat alam nyo yung remedy ninyo para you can protect your right. Okay? Remember, substantive law versus procedural law. Substantive law versus remedial law. Sa bar exam, maliit yung grade ko sa remedial law. 81 lang. Okay. Remedial law. Substantive law is the law that provides you the rights. Yung CMT is a substantive law because it provides you the rights. Okay. Yung procedural law such as the remedy on appeal, protest, remedial law yan. And you have to know the requirements in order for you to obtain the relief prayed for. If mali yung ginamit yung remedy, hindi tama yung hindi sa tamang office nyo final yung remedy ninyo, that would cause the dismissal of your case. Okay? Sabi nga nila, that would make the death of your case, that would be the cause of the death of your case. So you have to know your remedies. So under section 1106, if the district collector renders a decision against the importer, adverse to the importer, the remedy is to file a protest. To whom will you file your protest? To the Commissioner of Customs. Okay? To the Commissioner of Customs. Within what time? Okay? Within how many days you have to file your protest? Forever ba? Totoo bang may forever? No. Under the rules, you have to file your protest within 15 days from payment or within 15 days from the decision of the district collector. Yung payment dito refers to the not difficult question kasi di ba sa not difficult question within 48 hours ino-notify ka ni district collector with a directive to pay the duties and taxes. So ito yon. You start to count on this time within 15 days from payment. But if difficult or highly technical issue, di ba, magre-render muna si district collector ng ruling within 15 days. At kapag against you, then i-forfeit niya yung bond mo. Yung cash bond mo, hindi niya sisasauli. Hindi na niya, kukunin na niya yon, di ba? So that's the time you count the 15 days, okay, from the date of payment. In your protest, ganun din kanina, i-cite niyo yung batas. You cite the facts. Mag-storytelling ka. On this day, dumating yung shipment ko. On this day, I filed this corresponding entry. Attach mo yung entry mo. Okay? You cite everything that you want to, that happened. And then you cite the specific ruling that you objected to. Like for example, sa decision ni district collector, sa tingin mo mali siya kasi ginamit niya yung reference value. Eh sabi sa CMO, reference values are not substitute values. So you cite that. The district collector, the honorable district collector was wrong in appreciating the reference values because the CMO provides that reference values are not substitute values. So you cite the specific ruling and your basis. And lastly, you indicate the ground and relief. Ganun din. Parang tulad dun sa letter mo, sa pinakadulo, i-cite mo ano yung gusto mo mangyari. So ang gusto mo mangyari, tanggapin yung declared value mo at isauli yung cash bond mo. Okay? And once the protest is filed to the Commissioner of Customs, the Commissioner of Customs is given a period of 30 days to rule on your protest. What if lumagpas na sa 30 days, wala pa ring ruling si Commissioner? What does it mean? It means that the Commissioner agrees with the findings of the District Collector. In effect, inaffirm niya yung decision ni District Collector. Now, what if the Commissioner approves? What if the Commissioner denies your protest? In effect, inapprove niya, inaffirm niya yung decision ni District Collector. Is that the end of everything? Do you think that's the end of everything? What would be the next? What will happen next? Okay, may nagsabi dito Secretary of Finance. Okay? According to the rules, wag munang CTA. Nagsabi dito, nag-CTA muna. Wag muna mag-CTA, okay? Wag ka munang mag-CTA after this. What would happen? File ka muna ng okay. Before we go that, let's have some exercise. Let's have some question muna para mas ma-appreciate nyo yung dinidiscuss natin. Okay. The district collector issues an adverse ruling on July 1 and the importer received the same on July 3. Until when can the importer avail of the remedy? What do you think is the answer? Di ba ang remedy dito, protest? Di ba mag-file ka ng protest? So, kailan ba pwedeng mag-file ng protest si importer if this is the situation? Sige, can anyone answer? Okay. Until 15 days. May nagsabi until 15 days. Okay. 15 days from what? Meron din nagsabi dito, July 16. Okay, the answer here is depending on the date of payment because your remedy of protest is reckoned from the date of payment, di ba? Sabi doon, within 15 days from the date of payment. So depende kung kailang nagbayad. Kasi sa problem does not provide when the date of payment was, di ba? Ang binanggit lang niya on July 1 nag-issue ng ruling, on July 3 natanggap ni importer. Wala naman sinabing date of payment kasi nga yung reckoning period for the 15-day period to file the protest starts from or is based on the date of payment. So wala pang date of payment. So the period depends on the date of payment. So let us assume na meron ng date of payment. Nagbayad si importer ng July 5. Now, when do you think can the importer avail of the remedy of protest? Sige, mag-start na kayo ng count. So, okay, very good. So you start to count July 5. In counting periods, you do not include the first day. Huwag mo i-count yung July 5, ha? You count on the next day. So, di ba 15? 15. So, how do we count? July 5 is the first day. Do not count July 5. You start July 6. 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 10th day na. 16, 17, 18, 19, 20. That's the 15th day. So, until July 20. Correct. All of you are correct. Very good. You have until July 20 to file your protest. Okay. Let us say the importer paid on July 5. He filed the protest on July 21. What is the effect of the protest filed? What do you think is the effect of the protest filed on July 21? Okay. Okay, denied. Okay, request will be denied. Correct. Dismissible. Because late filing. Kaya nga, you have to know your rights. You do not sleep your rights. You have to know the period. Kasi importante yung mga period. Importante yung mga period. Because of late filing, dahil lang sa isang araw na late ka nag-file, the decision of the district collector became final and conclusive. So you can't do anything. You can't do anything. Wala nang available remedy kasi nga lumagpas na doon sa period within which to file. Maraming cases na ganyan na dumating sa akin. It makes my life easier kasi i-dismiss na lang namin kasi lumagpas na doon sa 15-day period. Okay? But I hope, alam nyo po, sa case naming mga evaluators, dalawang bagay po, dalawa pong instances na natutuwa kami. Natutuwa kami. We're very happy when two things happen. Number one, nung napakagandang sumulat nung importer kasi na-appreciate namin lahat na alam na namin yung lahat. Kung gusto niyang mangyari, legal basis niya nandun, it makes our life easier. Another scenario which makes our life easier if lumagpas doon sa period kasi it's easier for us to decide, i-dismiss. But I hope between the two, doon tayo sa una, ha? Huwag sa pangalawa. Doon tayo sa una, yung napakagandang pagsulat nyo, lahat ng attachments kompleto, lahat ng details kompleto, lahat ng legal basis nandun, at yung gusto nyong mangyari, isinulat nyo para mas maging happy tayo. Sabi nga na isang politiko, gusto ko, happy ka. Di ba? Yung politiko na yun, napakatanda na, serving now as the Chief Presidential Legal Counsel. Di ba? So dapat, happy tayong lahat. So that, in order for us to be happy, dapat na alam natin yung karapatan natin, dapat i-practice natin yung karapatan natin, dapat mag-file tayo ng available remedies within the prescribed period. Okay. Wait ha. Wait lang, malito. Nauna to. Meron pang unang tanong. Okay, wait lang. Okay, sandali lang. Okay. So, okay, dismissible. Now, the importer did not pay. He filed the protest on July 19. What is the effect of the protest? Hindi siya nagbayad, dumiretso siya nag-file ng protest. What do you think is the effect of the protest? Anyone? Okay, dismissed, denied. Why? Because payment is required. Okay, dismissible because lack of payment. There must be payment in order for your protest to be valid, in order for the commissioner to acquire jurisdiction. Yan yung ginagamit namin na phrase. The commissioner did not acquire jurisdiction because of the failure of the importer to pay. Because payment is essential for jurisdiction to be acquired. And what is jurisdiction? Jurisdiction is the authority to hear and take and decide a case and to enforce its decision. So kung hindi ka nagbayad, walang jurisdiction si commissioner. Dismissible. Okay. Another scenario. The importer paid on July 5. He filed the protest on July 19 before the district collector. What is the effect of the protest? What is the effect of the protest? Okay, very good. Ang galing naman ng mga attendees natin. Mga practicing brokers ba to o mga estudyante? Okay, parang nag-aaral lang ah. Okay. Can we ask if are you students ba or practicing customs brokers or lawyers now? Kasi napakagaling yung sumagot.
I think I know the answer. It's because
Yes,
you
what's your
explain
answer?
very well.
Yes,
You
what's your
explain
answer,
very well.
Sige nga,
And so-
what's your answer? Sige. So, I think the answer is clear, di ba? Requirement doon to file a protest before the Commissioner of Customs. So, you filed your protest before the district collector, effect, dismissible because of wrong venue. Wrong venue. Hindi tama yung opisinang finailan mo ng protest. So, dismissible. Okay? Kaya pala. So, stakeholder pala ni Bureau of Customs. Kaya napakagaling ng ating mga attendees. Okay? So, what if the commissioner renders a decision against the importer? Hindi niya tinanggap yung inyong protest. Sabi niya, ay mali ka importer. Tama si district collector. I agree with my district collector. I agree with my customs officers. What would be the available remedies? Meron pa ba? What do you think? Merong nagsabi, appeal to Court of Tax Appeals. Merong nagsabi, appeal to Secretary of Finance. Okay? What's the answer? According to the rules, the next available remedy is to file for a motion for reconsideration. Motion for reconsideration ka muna. Ano yung basis mo? Newly discovered evidence. Like for example, di ba, kulang ka ng bank transfer document. Di ba, sabi nga natin kanina, you only have 5 days to submit your documents. Nagkasakit yung branch manager, nagkasakit yung bank manager. What if something happens na lumindol, di ba? Nandun sa area na napakalakas ng lindol ng bangko, nagiba yung buong bangko. So, you were not able to submit your document. Pero, after ilang araw, you were able now to secure your bank transaction record. Hindi mo yun na-submit doon sa district collector. Hindi mo yun na-submit doon sa protest mo kay commissioner. But right now, you have now your proof of payment. So what is your next remedy? Mag-file ka ng motion for reconsideration before the Commissioner of Customs within 15 days from the receipt of the ruling ni Commissioner. And you cite your newly discovered evidence. Yung usual kasi na basis for motion for reconsideration is newly discovered evidence which through exercise of due diligence could not have found the document. You could not have found the document because these were not in your possession during that time. Okay? So newly discovered evidence, or merong bagong batas na favorable sa iyo, merong bagong customs memorandum order na lumabas at favorable sa iyo. So pwede mong i-cite yan sa motion for reconsideration mo. Okay, now, let us assume that the commissioner grants your motion for reconsideration. Di ba? Bakit ka umakyat kay commissioner? Kasi hindi ka nag-agree kay district collector. Kaya nag-protest ka. Sa protest, sabi ni commissioner, tama si district collector, mali ka pa rin importer. But nung nag-file ka ng motion for reconsideration, tamang-tama nag-join ka sa webinar natin ngayon, naintindihan mo yung remedy mo, sinunod mo yung suggestion natin, sinunod mo yung tips natin na napagandahan mo yung sulat mo, na-convince mo si Commissioner dun sa motion for reconsideration mo. What do you think is the effect of the ruling of the Commissioner granting your motion for reconsideration? What do you think is the effect of that ruling? Sige nga. Okay? Okay, valid and accepted. And as far as you're concerned, that ruling is effective immediately. Okay, it's effective immediately. Bunta ka agad kay district collector. Kunin mo na yung cash bond mo, 'di ba? Singilin mo na yung sobra mong payment. Okay, it becomes effective immediately. Now, pag naningil ka doon kay district collector, sabi ng district collector, aba, ano kayang sikreto ng importer na to? Oh, galit si district collector kasi binaliktad ni commissioner yung decision niya. Sabi ni district collector, puntahan ko nga si commissioner, i-appeal ko nga yung decision niya na i-grant yung motion for reconsideration mo. Ang tanong ko, pwede bang gawin ni district collector yan? I-question niya yung decision ng higher up niya? I-question niya yung decision ni commissioner? Can the district collector do that? No. What's your basis? Bakit yung sinabing no? Sige nga, practicein natin yung tip ko sa inyo. What's your legal basis in saying no? What's your legal basis in saying no? Hindi enough na nag-no ka lang. There's a legal basis. Ano sa tingin niyo yung legal basis? What do you think is the legal basis in saying no? Sige nga, may legal basis. The district collector is the higher position to decide, or maybe the commissioner is the higher position to decide. Okay? The legal basis is this. No, because there is no law allowing such remedy. Wala sa CMTA na sinabi na kapag nag-agree si Commissioner of Customs doon sa protest case, pwedeng mag-appeal si district collector. So district collector cannot do that. Okay? Because there's no law providing for it. Number two, tama din kayo because the commissioner is the higher authority of the district collector. And the commissioner has the power to review the decision of the district collector. Kaya nga nagpo-protest kayo para ipa-review nyo yung decision ni district collector. And when the decision of the district collector is being reviewed by the commissioner, pwede talagang ibaliktarin ng commissioner yung decision ni district collector. And that's part of the job. Okay, that's part of the job. Walang mapipikon po sa ating mga district collector. That's part of the job. Siguro napakagaling lang talagang sumulat noong importer sa motion for reconsideration niya. Kaya na-convince niya si commissioner. What if, assuming, doon sa motion for reconsideration mo, hindi ka pa rin grinant ni commissioner. Okay? Hindi mo pa rin na-convince si commissioner. What would be your next remedy? Sige nga. What do you think is your next remedy? Okay, very good. Go to Court of Tax Appeals. Mag-judicial appeal ka na. Okay? Go to Court of Tax Appeals within 30 days from receipt of the ruling denying the MR by the commissioner. Sasabihin nyo, tatanungin nyo siguro, napag-isip nyo ba, Sir, bakit ngayon lang tayo magko-Court of Tax Appeals? Pwede naman siguro after the district collector, diretso ako sa Court of Tax Appeals. Kasi pupunta din naman tayo dun eh. Pupunta din naman pala tayo dun sa Court of Tax Appeals, diretso na lang ako. 'Di ba? Para lang tayo, 'di ba? What if for example, after the end of the day, gusto niyo palang kumain lang pumunta ng Batangas. Ba't kayo papadadaan ng Manila kung pupunta lang kayo ng Batangas? 'Di ba? O ba't pa kayo dadaan ng Cebu kung pupunta lang pala kayo ng Davao? Ganon din. Bakit pa ako dadaan ng commissioner papunta din naman ako ng Court of Tax Appeals? What do you think is the answer? Okay. Sir Antonio is correct. Primary jurisdiction, that's correct also. That's another doctrine in customs law. That's very good. Is Sir Antonio a lawyer po? Is Sir Antonio a lawyer, a law student, or a practicing customs broker? Kasi napakaganda po ng sagot ninyo. I am interested to know. Sir Joseph. Okay, Sir Joseph, and is Brainard po ba? Brainard is a gentleman. Sir Antonio, LCB. Very good, sir. Very good. Okay. So, doctrine of primary jurisdiction. Tama din si Sir Joseph and si Sir Brainard. Yung answer nila, yung mas tama doon. Okay? The doctrine of exhaustion of administrative remedies. What is that? Ito yung tinuturo ko sa mga estudyante ko sa customs administration, pati sa graduate school na kapag in relation to customs administration. Ang usual kasing alam natin, kapag may kaso, kapag may gusto tayong gawin, didiretso tayo sa korte, di ba? Magfa-file agad ng kaso sa korte. That does not apply in this case because we have the doctrine of primary jurisdiction. We have the doctrine of exhaustion of administrative remedies. What does the doctrine of exhaustion of administrative remedies provide? It says that before a party is allowed to go to court, before ka pumunta sa korte, you have to exhaust, you have to avail all available remedies within the administrative machinery. Okay, within the administrative machinery. Okay, you have to avail lahat. So, hindi ka muna pumunta ng Court of Appeals. Pumunta ka muna, dumaan ka muna kay Commissioner of Customs. If resort to a remedy within the administrative machinery is available, then you have to avail of that opportunity because, number one, kasi you give the administrative body the chance to review its ruling. Okay? Diba? From district collector, hindi ka dediretso sa korte. Why? You give the commissioner a chance to review the decision of the district collector. You give the commissioner a chance to review the decision of his subordinate. Diba? Okay, thank you, Sir Brainard. So you're working in MICT, sir. So thank you po, sir. Very good po, sir. Very good po yung sagot ninyo. Number two, kung lahat ng tao pupunta sa korte, ang daming kaso ng korte, di ba? It will, sabi nila, it will declog, it will clog. Di ba? Para lang yang, sorry ha for the analogy. Para yung toilet bowl, di ba? Kung yung tissue isasama mo dun sa pag-flush, mag-clog yung septic tank. Eh, di ba? So, hindi mo na mapa-flush yun kung may gagamit pa ulit. Yun yung problema namin sa opisina namin. Di ba? Ang daming gustong mag-flush ng tissue. Eh, nandun namang yung trash bin. Ayaw ilagay dun sa trash bin. Gusto talaga dun sa toilet bowl. Di ba? So, yun, magka-clog yung toilet bowl. Para din yung hukuman. Kung lahat ng kaso, idadaan mo na sa hukuman, then mag-clog yung dockets. Mapupuno ng kaso yung hukuman natin. And because there is an available remedy, malilesen, di ba? Malilesen po konti yung kaso sa korte kasi there is an available remedy in the administrative body. Kaya that is the doctrine of exhaustion of administrative remedies. Now, what if? Anong effect kung i-violate mo yung doctrine of administrative remedies? What do you think is the effect? Let us say, for example, galing ka kay district collector, dumiretso kay Court of Tax Appeals. What do you think will happen to your case? Sige nga, can we ask? Okay, denied. Kama, denied. Bakit denied? Number one, lack of jurisdiction. Why? Kasi walang jurisdiction si Court of Tax Appeals. Number two, denied because of violation of doctrine of exhaustion of administrative remedies. Now, for you who are not familiar with the Court of Tax Appeals, yung Court of Tax Appeals po, di ba sa level ng ating hukuman, ang pinakamataas po, Supreme Court. Kaya nga, Supreme Court. That's the last court. Okay? I was given the chance to be in the Supreme Court when I took my lawyer's oath nung pumunta kami kay Supreme Court. So that's the last court. At baba ng Supreme Court, meron tayong mga appellate courts. Okay? Appellate courts. Ano yung mga appellate courts natin na collegial courts? Number one, Court of Appeals. Number two, Sandigan Bayan. Number three, Court of Tax Appeals. Okay? Court of Tax Appeals. Yan. So, Court of Tax Appeals is a court. It is a court of specialized body. Bakit specialized body? Why is it a specialized jurisdiction? Because hindi po lahat ng kaso dadaan ng Court of Tax Appeals. Merong pinatay. Anong kaso niyan? Kung merong pinatay, what do you think is the case? Sige nga, dito, tingnan nga natin if alam nyo, basic na tanong. Okay, sabi ni Miss Jackie, murder. Okay, wala bang ibang sagot? Pinatay ko yung lamok. Murder na yan. Pinatay, oy, Miss Divine, you're here, Miss Divine. Okay, Miss Divine is one of our brokers in the Port of Cebu. So, homicide. Okay, I think Alam to ni Miss Divine kasi yung kapatid niya nag-aaral ng law. Magiging abogada yung kapatid niya. Kasing pareho nung pangalan ni Miss Jovelyn, di ba? Jovelyn. Si Jovelyn ay isang law student. Magiging abogado din. Galing. Galing na sagot ni Sir. Insecticide. Okay, insecticide. Kapag pumatay ka ng tao, homicide yan. Unless there are aggravating circumstances like poison, okay, lack of sufficient treachery, okay? Kung pinatay mo yung tao na nakatalikod, he was not able to defend himself, that's treachery, then that's murder. Pero kapag walang treachery, walang evident premeditation, walang use of poison, ganito, it's only homicide. Okay. So kapag homicide, dun ka sa RTC, Regional Trial Court. Hindi ka pupunta sa Court of Tax Appeals. Kasi nga, ang jurisdiction ni Court of Tax Appeals, tax cases lang. Okay? Tax cases lang. BIR, Bureau of Customs, Secretary of Finance, ganon. Gandang sagot mo, sir, insecticide. If killing a person, what crime is committed? Homicide. If you kill a person who is related to you, asawa, tatay, nanay, anak mo, apo mo, anong crime? Parricide. Okay? Correct. Parricide. 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 Kapag pumatay ka ng isang bata na less than 3 years old, infanticide. Very good. Ang galing ng mga participants natin yun na. Hindi lang mga customs brokers, mga future lawyers din. Baka lawyers na rin kayo. Diba? Kapag pumatay ka ng tao, homicide. Kapag pumatay ka ng kamag-anak na within 1 degree, parricide. Kapag pumatay ka ng bata na less than 3 days old, infanticide. Tama si sir, kapag pumatay ka ng ipis, insecticide. Oh, magandang joke yun, sir. Ha? Thank you for the idea, sir. Ha? Insecticide. Okay, now, we go back to the discussion. Court of Tax Appeals is a special case. Malapit nang matapos yung allotted time natin. So, Court of Tax Appeals, it is a special court because it only acquires jurisdiction or it has jurisdiction on tax cases. Okay? And the Court of Tax Appeals is composed of a presiding justice and 8 associate justice. And they do not work as one. Okay? Hindi siya en banc. En banc means the whole court. They work by division. Division muna of 3. So 3 divisions. Okay? 1 division, 3 justices. So your remedy is to file an appeal to the Court of Tax Appeals. What if sa level ni Court of Tax Appeals, sabi ni Court of Tax Appeals, tama si Commissioner of Customs, mali ka importer. What's your next remedy? What do you think is your next remedy? If meron pa. Okay? Your next remedy is umakyat ka na sa pinakamataas na hukuman sa Supreme Court. Okay, sa Supreme Court. And in the Supreme Court, okay, sa Court of Tax Appeals, 30 days. Mas mahaba. Sa Supreme Court, 15 days na lang from receipt of the ruling of the Court of Tax Appeals en banc. Okay? So, let's have some questions. If the commissioner denies the MR, what is the remedy of the importer? Okay, Court of Tax Appeals. Okay, alam nyo na yung sagot dyan, kaya lumabas na agad yung sagot. Okay, pahirapan natin ng konti yung tanong. The commissioner denied the motion for reconsideration on June 15. The importer received the denial on June 28 and filed the appeal on July 20. The BOC moved for the dismissal of the appeal because of late filing, arguing that the period to file the appeal already lapsed on July 15. Question, is Bureau of Customs correct? Okay. Is Bureau of Customs correct? Kailan nga yung prescribed period to appeal? Diba? You are given 30 days. So, saan magka-count yung 30 days? Doon tayo magkakasubukan. Sige nga, what do you think is the answer? Do you think BOC is correct? No. What's your legal basis? Bakit no? Why no? Why not yes? Di ba 30 days? O 30 days from June 15, July 15. So tama si BOC. 30 days, July 15 din. Correct, Miss Teresa. The law provides that the reckoning period is on the time of receipt. Bakit hindi yung date of issuance. Because at the date of issuance, hindi mo pa alam, di ba? Hindi mo pa alam yung decision. And when you do not know the decision, you do not know what to do. That is why the starting period would be from the date of receipt. So, yung counting mo ng 30 days from the date it was received. Because only when you receive the notice that you know what to do next. Okay? That's the essence of due process. It's always from the time of receipt of notice. So, June 28. So, 30 days from June 28, July 28. So, yung July 20, pasok pa rin doon sa 30-day period. So, the BOC is not correct because the 30-day period starts to count on the date of receipt of ruling and not the issuance. Let us say, for example, the Court of Tax Appeals affirmed the ruling of the commissioner. What is the remedy of the importer if meron pang remedy si importer? What do you think? What do you think? What do you think is the remedy of the importer if meron pa? Okay, very good. The remedy is Supreme Court. File an appeal to the Supreme Court via petition for review via certiorari within 15 days from receipt of the decision affirming the ruling of the Commissioner of Customs. Okay, so that ends my presentation. Tama pa yung oras. I think hindi tayo lumagpas doon sa allotted time. So,
Indeed, yes. And we have a few minutes, Attorney Andaya, for their questions. Ang daya mo kasi ikaw ang nagtanong ng questions sa kanila.
yan yung technique ko, Miss Mariel, para ma-check natin kung mas naintindihan ba nung mga attendees.
Yes. And go ahead for those of you who have questions. Nakita nyo naman, from customs value to dispute settlement to remedies, everything answered. But in case there are other questions that you might have or any doubts, go ahead, type them in the chat box.
Yes, please.
I believe, Mr. Andaya, parang kanina merong question if you go farther.
Yes, there's a question here.
Yeah, there was one.
Yes, if the customs examiner subjected your value for ES evaluation, even though you have submitted all documents required, is it okay to write for dispute settlement to the appraiser, Fed chief, debt call for assessment? Yes. Okay, let me just clarify ha. There is already a memorandum. I'm just not so sure kung merong exemption. Kasi may dati kasi, for the benefit of our attendees, may mga certain commodities that would require submission to IAS. Ano yung IAS? IAS is an office under the Assessment and Operations Coordinating Group. IAS stands for Import Assessment Service. Import Assessment Service determines the value of certain commodities. That's before. But there is a memorandum issued by the commissioner saying that IAS clearance is no longer needed. So no longer needed. Why? Because the value now can be seen through the E2M system. Kaya yung meron na tayong Enhanced Value Reference Information System. When the EVIS was there, IAS clearance was no longer required. Now, just to answer your question, yes, while waiting for the response, if ever lang, babalik tayo dun sa IAS clearance. While waiting, you can file for a dispute settlement case.
A lot of them are already saying thank you, Attorney Andaya. Oh, thank you, sir. Thank you, sir.
Okay. You're welcome. Thank you also. So another question here, Ms. Mariel. How
Yes.
about if there's an indirect transaction? The seller contracts another manufacturer who sends the goods to the buyer and the commercial invoice reflects the name of the manufacturer and the buyer made the payment to the seller. Proof of payment does not reflect the name of the manufacturer but the name of the seller instead. Now, so ibig sabihin, different yung name ni importer sa single administrative document and the other documents. In that particular case, if I'll be the case evaluator, I would ask you to give me a proof to establish your relationship. What kind of relationship? That the person to whom you paid the money or to whom you paid the price is related to the seller. Ganun lang, just to establish lang the relationship that the transaction was between, there's a sale transaction between the buyer and the seller, whoever be the seller or the buyer is. Basta ma-establish na natin yung relationship ninyo. then that could be accepted. That's my opinion on that matter. Another question, wait lang ha. Okay.
The question got drowned now with all the thank yous, sir.
Yung lodgement po through VAPS, is that considered nag-file ka na or need mo i-click yung send? Sir, what do you mean by this, sir? Sir Ronald? Ano po ba yung ibig niyong sabihin sa nag-file? Do you mean the goods declaration?
He can clarify.
Okay, if you mean the goods declaration, if you refer to the 15-day period, the lodgement po refers to the submission through the value-added service provider. Yung filing po ng hard copies kay CCC is not the period of lodgement. Because ang period of lodgement kasi is determined in the system. So once may registration na sa system, kaya nga when you lodge your goods declaration, ang nakalagay registered, di ba? I think Ms. Divine and some of our brokers here can attest that when you lodge your goods declaration, ang lalabas doon registered because naka-register ka na sa system. And once your status is registered in the system, then you have complied with the 15-day period. But that does not end there. Kasi meron pa ring abandonment if you do not pay the duties and taxes within 15 days from date of final assessment. But that topic is on the next webinar, yung topic on abandonment. Sige, let me check another. Sana sir, may say din si BOC for storage. Problema kasi we want to avail the remedies, kaso problema ng importer is the storage ng goods na lumalaki. Kaya nga meron tayong release under tentative assessment. That's your remedy because the goods will be released. Diba? So, sabihin nyo, sir, tatagal pa yan. Gawin nyo ganito. In the morning, puntahan nyo si examiner. Pag ayaw niya, okay, you go at 8 a.m. Pag ayaw ni examiner, punta ka ng 10 a.m. kay appraiser. Pag ayaw pa rin, before lunch, punta kay chief ng assessment division. After lunch, punta kay deputy collector. O pag hapon ayaw pa rin, demiretso ka na kay district collector. Tapos lagay mo dun sa prayer mo na yung goods mo perishable in nature. O di ba, kailangan mong ma-release yung shipment mo within a reasonable period of time para may sense of urgency din na alam ni case evaluator or the district collector that there's some sense of urgency on your shipment. Okay? And then you file, magsisimula kasi ito lahat sa filing na as a lodgement of goods declaration. Mag-lodge kayo agad. Okay, mag-lodge kayo agad para hindi kayo maproproblema doon sa free storage period nyo. And that's also part of the risk. Okay, part talaga yan ng risk. If you engage into business, there will always be risk. So meron talagang mga cost na ganyan, di ba? So but of course, if you know your remedy, if you know what to do, then it would help you. Diba? It would save you from these unnecessary charges and costs. Contract between the buyer and seller is CIF. Amount in PO is on CIF amount. Can this be used as declared value? Yes. Kasi nga, i-deduct. Okay. The CIF, cost, insurance, and freight, includes the cost of the insurance premium and the freight. In order to arrive with the customs value, you just deduct the insurance and the freight. So, anong gagawin mo? Make sure that you have the marine insurance, okay? To prove in order to get the customs value. So as long as the documents are there, Miss Jean, pwede namang tanggapin yan ni customs as long as you have supporting documents. Hi sir, how about po ang treatment pag may sales discount? Ang customs value po ba ay PAPP without the discount? No. It excludes the discount. Nandyan po yan sa rules on customs valuation. If merong discount, show proof na merong discount. Pag nasa kontrata ninyo na may discount, then provide the sales contract. And then cite doon, i-highlight nyo anong provision doon sa sales contract ang nagsasabi merong discount for this particular transaction. Then that might be acceptable to customs. So regarding sa ruling ng COO, okay, Certificate of Origin. Sige, although our topic is customs valuation, we'll try to answer your concern on COO. What if the product was transferred to another container at the transshipment port? Shall we use the USDA? Ano po yung USDA? I'm sorry, I'm not familiar with the acronym USDA. or will require pa ng certificate of origin if it was transloaded at Singapore or China? Okay. Rules of origin, meron kasi tayong mga originating requirements. Kung transshipment lang, walang substantial transformation, then the country, dalawa kasi yan country of export and country of origin. When you say country of export, yan yung port kung saan ano ba yung term? That's the port where the carrying vessel came from. Okay, like for example, kung from China to Philippines. So China or Shanghai, for example, that's the country of export because that's where the carrying vessel came from. But the country of origin is different. The goods may come from Shanghai, China, but it originated from another country. So ang rule natin dito is not the country of export, it's the country of origin. So kung nag-transshipment lang, there was no substantial transformation, there was nothing that happened there other than transshipment, then the country of export is not the country of origin. So, for example, if Singapore talaga yung origin ng goods, pero nag-transshipment lang from another country, then the rules of origin would apply as far as Singapore is concerned, not the transshipment port, because it is not considered as the country of origin. I'm not familiar with USDA. I'm sorry po, Miss Teresa. Okay. Sir, in dispute on customs valuation, is there any way that SOF can interfere on the matter? Like in dispute, okay. Iba po yung customs valuation, iba din po yung tariff classification. Customs valuation has something to do about the value of the goods. Tariff classification has something to do about the tariff classification. Dito po sa discussion ko, walang Secretary of Finance because my focus is on customs valuation. But if you're asking on tariff classification, under the rules, if my memory serves me right, meron pa ring distinction between a highly difficult or technical question and a not difficult or highly technical question. Kapag yung tariff classification issue is highly difficult or technical, what would happen is from the Bureau of Customs, i-refer ni District Collector kay Tariff Commission yung matter for dispute ruling. Okay. From Tariff Commission, mag-issue siya ng ruling. If the decision is favorable to the importer, then binding yan kay whatever the decision of the Tariff Commission is, binding yan kay Bureau of Customs, except when the Secretary of Finance rules otherwise. So for example, nag-declare si importer ng tariff classification heading na 0% rate of duty. Question ni examiner, sabi ni examiner, no, that's wrong. Ang dapat niyang tariff classification is under this tariff heading na 10% rate of duty. Eh syempre, lugi ka. Ikaw na importer kasi magbabayad ka ng customs duty. Supposedly, wala. Pumunta, ngayon, the case was considered to be difficult question. So, pupunta ng Tariff Commission for a dispute ruling. Pagdating sa Tariff Commission, sabi ni Tariff Commission, tama sa importer. Tariff heading with 0%. So, lugi si customs kasi instead na makakasingil siya ng customs duty, hindi na siya makakasingil. So, unfavorable to him, unfavorable to BOC yung decision. Ang gagawin ni BOC, elevate niya kay Secretary of Finance yung issue. Okay, dyan lang papasok yung Secretary of Finance. What if naman hindi difficult or technical yung concern? Then from District Collector, you go to file a protest to Commissioner of Customs. Then from Commissioner of Customs, you can go to Tariff Commission. And then Tariff Commission, pwede ka mag-elevate kay Secretary of Finance, tapos Court of Tax Appeals, tapos Supreme Court. So, sa tariff classification lang, merong role si Tariff Commission because under the CMTA, the authority to decide on the proper tariff classification is vested upon the Tariff Commission. Pero pag yung issue customs valuation at saka rules of origin, the decision is within or is vested with the Bureau of Customs. Okay. Remedy available for temporary importation. What do you mean by temporary importation, Ms. Hazel? You mean importation without payment of duties and taxes? So kung walang babayaran duties and taxes, there's no need for us to determine customs value. So I think there's no dispute as to that. Okay? If my interpretation of temporary importation is correct, for split shipment, NSW value po ba i-follow or commercial invoice? Commercial invoice, of course. Okay? Commercial invoice. Kasi yan yung basis mo. Remember, I cited the section 412 earlier that the price actually paid or payable must be reflected in the invoice. So what matters or what is binding is the invoice. So dapat yung value mo should be indicated in your invoice value. Let me take you for an example. Actual case ngayon. Nahihirapan akong mag-evaluate. Yung shipment niya, gas. So yung gas, hindi mo naman pwedeng i-ship yung gas in its gaseous form, di ba? Dapat mo siyang ilagay sa isang container. So the gas is placed in a cylinder, yung tangke. Now, yung tank kapag ilagay mo sa container, aalog yung barko, aalog din yung container. So magmo-move yung cylinder. So ginawa nila, nilagyan nila ng parang basket na steel basket yung cylinder para fix siya, hindi siya mag-move. Ang problema, sa invoice niya nakalagay yung value ng gas, yung value ng cylinder, yung value ng basket, saka yung freight. 4 na components. Pero ang binayaran niya, gas lang, saka yung freight. Hindi niya binayaran yung steel basket. So how will you prove that the value declared in your invoice for the steel basket is the price actually paid or payable when in fact you did not pay for it? Diba? And if there's no sale transaction, doon tayo sa method 1, method 2. So magagamit yung reference values doon sa EVRIS because these are values of identical and similar goods. Okay, so I would suggest that you follow the value indicated in your commercial invoice. Sir, will conversion processing be considered substantial transformation? I'm not an expert on this matter. Let me get back to you on that. I can't answer you at this moment yung substantial transformation kasi meron yang processing. Okay. If I can still recall, yung substantial transformation may either be a change from the tariff heading, okay? From, 'di ba, yung AHT natin may chapters yan, chapter 1 to chapter 99. If yung first product mo is classifiable under a specific chapter, and then meron kang processing doon sa conversion, if that conversion processing will change the tariff classification from chapter 1 to chapter 2, then there is substantial transformation because there's a change in the chapter. Okay? Pero kapag walang transformation, classifiable pa rin under this chapter, classifiable pa rin under the same tariff heading, then there's no substantial transformation. I believe there's no substantial transformation. So kung block cheese siya, tapos nag-slice ka lang, and then the same tariff classification pa rin yung block tsaka yung slice, then there's no substantial transformation. So anong sinasabi, ano yung essence ng sinasabi ko? Kapag yung block cheese galing ng Australia, block pa siya, dumaan ka ng Singapore at isninice mo doon sa Singapore, yung block, nag-slice ka doon sa Singapore, and in the Philippines, upon arriving in the Philippines, sinabi mo the cheese originated from Singapore kasi nag-slice ka doon. It does not comply with the substantial transformation requirement kasi nag-slice ka lang doon sa Singapore eh. Cheese pa rin yan. Pero kung block cheese siya from Australia, pumunta ka ng Singapore, ginawa mong milk or whatever finished product, and then there's substantial transformation. Even if originally the block cheese came from Australia, pero may substantial transformation na nangyari sa Singapore, then the cheese could be considered, or whatever finished product can be considered as having originated from Singapore because there is substantial transformation. And in that case, you can avail of preferential tariff kung meron man. Sir, what if there's a discrepancy in the decimal like 0.01 sa invoice versus tax invoice? I'm sorry but I'm not familiar. Anong difference ng commercial tsaka yung tax invoice? Commercial, yan talaga yung binayaran namin. Yung tax, yan na yung i-declare namin. Is that what you mean by commercial and tax invoice? Now, if merong discrepancy and you can validly explain that the discrepancy was not intentional, the discrepancy was inadvertently made, and the same was made in good faith, then pwede naman, tatanggapin pa rin yan ni customs kahit may difference. Okay? But as long as there's no bad faith, there's no fraudulent intent. But kung yung discrepancy, like for example, yung dineclare mo 1,000 pesos, tapos yung invoice pala 100 million peso, napaka-glaring ng discrepancy, di ba? In effect, pinaliit mo talaga yung value kasi you want to undervalue. So mahirap naman i-explain mo yan, di ba? May actual scenario yan pero sa weight lang. Nagkamali nag-encode doon si freight forwarder. Nagkamali siya nag-encode. Instead of 100,000 kilograms, ang in-encode niya, I think, 9,000. Oh. Pero mahirap din justify kasi yung 1, napakalayo nung 1 sa 9. Di ba magkabilang dulo sila? So, kung sasabihin mong inadvertent lang yung pag-type, dapat kung 1, 2 siguro. Kasi malapit yung 2 sa 1. Pero pag 9, ipagkaibang dulo unless yung keyboard mo baliktad. 1 tsaka 9 magkatabi. Pwede siguro ma-justify mo, inadvertent error yon. Pero pag napakadulo, magkaibang dulo, medyo mahirapan tayong i-substantiate yung claim that it was inadvertently made. Okay? Medyo nawalan. Okay. Dumami kasi yung mga questions. Tama po ba na i-add sa form FOB value ang form E cost para makuha ang customs value? Okay. Meron kasi instances na yung form E value different from the invoice. Now, between the form E and the invoice, ang basis for customs value is the invoice. Kasi nga, yung form E, okay, ganito ha, yung invoice is a proof of sale transaction. It's a document issued by the seller for the buyer as proof that there was sale transaction. Yung CO po is a document issued to prove the origin of the goods. It does not prove any sale transaction. So between the value in the CO and the value in the invoice, it is the value in the invoice that proves the sale transaction. It is the value in the invoice that proves the price actually paid or payable. So if you ask me between CO value and invoice, doon ako sa invoice because that is your price actually paid or payable. Commercial invoice is the document we use in clearing, while the tax invoice is document paid to supplier. Okay. So if bakit magkaiba yung dalawa? Bakit may kaibahan? So let us just say, for example, kung yung tax invoice, yan yung document mo to show proof na yan yung binayaran mo kay supplier, then tax invoice, the value of the tax invoice will be used. But take note, possible na problema yan. Kasi kung dalawa yung invoice mo, remember, in section 412, basahin ko lang yung section 412 para alam natin. I'm sorry, I'm not so familiar with tax invoice, with those things kasi accounting practice yan. But under section 412, if I can read for the benefit of all, nakasaad dyan sa section 412, letter B, to the best of the declarant's information and belief, all the invoice, okay, the invoice is the only one in existence relating to the importation in question. Now, kung dalawa yung invoice mo, problema yan, delikado kasi nasa batas. Dapat yung invoice mo should be the only one in existence. Di ba? So kung dalawa pa lang invoice mo, ang interpretation, ang impression niyan kay customs, dalawa yung sinubmit mo. Kung saan yung mas mababa, yun yung ipipresent mo sa amin. So kapag ganyan, there is an impression of undervaluation. I'm sorry ma'am ha, hindi kasi ako masyadong familiar dun sa accounting process, but as far as your question is concerned, I would suggest yung commercial invoice because that is the one showing the sale transaction. Okay? Sir, what is the legal basis for 3% as other charges pag ex-works and input terms? I'm sorry, I cannot answer your question because I have not read the 3% additional for ex-works. So I cannot answer the legal basis. Sir Kevin, with all due respect, you ask the customs examiner anong basis niya dun sa 3% na additional for ex-works. Politely ask him lang po. Sabihan mo, sir, may we know po ano po yung basis ng 3% natin. And if ever may document siya, then you might accept it. But otherwise, hindi yan pwede. I'm sorry, I cannot answer your question kasi I have not read such legal basis for the additional 3% pag ex-works. Sir, what about po if the seller indicated in the invoice of the goods is not the shipper of the goods? What do you mean? What do you mean, Miss Jonalyn? I think si Miss Jonalyn, if not mistaken, taga Bohol siguro to, si Miss Jonalyn. Or baka ibang Jonalyn yon. May Jonalyn kasi nag-attend din sa mga lecture ko. And then very participative din. So, if the seller in the invoice is not the same as the shipper, is going to be accepted. Okay, remember po doon sa definition ko kanina that as long as there is a seller and buyer parties, as long as there are seller and buyer parties in the transaction, then there is a sale transaction. So, as long as you are able to substantiate your claim na si X ang seller, si Y ang buyer, kahit na si Z yung nandun naka-indicate, okay, so as long as you can able to establish that, as you're able to establish that. But I would suggest, mahirap kasing i-substantiate, di ba? Ang dami mong iisipin, paano ba to? How do I connect this X to Y? Mas mainam yung document mismo, klaruhin na natin. From the document itself, iklaro na kung si X ang buyer, si X ang ilalagay. Kung si Y ang buyer, si Y ilalagay. Kung si Z ang seller, si Z ang ilalagay. Okay, para at least hindi na kayo mahirapan. Hindi na rin mag-question si customs, but ito, ganito, iba naman yung pangalan dito. So it's a question of ownership na naman. Di ba? So baka sabihin naman, baka dami to. Di ba? It might be an enforcement issue. So yun, I would suggest to our stakeholders, dun pa lang sa documents ninyo, ayusin na natin para hindi siya maging issue later on when you present these documents to Bureau of Customs.